I beg to mention item number 16 of your lordship's list. In this case, need to file an affidavit in IA 2362. So at least 2 weeks to 3 weeks time, I need to file an affidavit.
Mr. Counsel, I don't allow this at this time any adjournment on the ground of filing of affidavit.
No,
You
I
may
need to
say
file
that
an
having
affidavit.
the fallen, and as such, you are not in a position to argue the matter, I would allow you. Although the heavens have not fallen,
Pardon, lordship.
but not at the cost of filing an affidavit in reply.
But I need to, means there are some.
Understood. So when the matter is reached, you do it, not now.
With please, your worships. Well, I beg to mention for listing of the repetition for motion tomorrow, my lord. A contextual matter, my lord.
What is the urgency?
My lord, here, my lord, petitioner was, financial bid was open, my lord. He was declared as alone, my lord. Now, my lord, what happened, my lord? They are, my lord, intending to hand over the work to L2 bidder, my lord. And they are cleaning the site, my lord. So, my lord, I have the genuine apprehension, my lord. So, your lordship's interference
It's
is
against Mr. B. Gogoi?
no, my lord. It is water issue department, my lord.
It would be against B. Gogoi, it was a surety you would have got a stay.
My lord. Tomorrow, my lord.
Nowadays, I have taken another, apart from the 3 conditions for grant of a stay,
My lord.
I also have Mr. B. Gogoi on the other side. That becomes an additional ground. Yes.
Right.
Okay, tomorrow.
My lord.
May it please your lordship. Lordship, with regard to item number 17, we're filing our affidavit in opposition. My prayer is for call for requisition, lordship.
Okay.
Lordship.
May I please, your lordship, I would like to mention for listing a WBC number 11
For admission orders,
for admission.
what is the matter about?
This matter, someone is using my PAN card. He has taken 4 loans against my PAN card. When I approach the bank, they are saying that your PAN card is.
It happens to be a bench 5 matter.
Pardon?
Bench 5 matter. Go before court number 6. Thank you.
Obliged.
Madam, did you file an application?
We filed an affidavit.
Madam, your case is now covered by this judgment. Kumudlal, have you looked into that? Kumudlal. No. It's for me to find out. And therefore, I've asked my stenographer to make 2 copies, knowing fully well that you would not be prepared with it. Your client is in a better place, so therefore I'm not giving you a copy. You see, 306 have been duly taken into consideration by the Supreme Court in the judgment. And kindly come to paragraph 64. Paragraph 64.
I read it.
Read it.
Yes.
Go.
This is, Lordship, if Lordship allow me to submit my submission, Lordship. This is with regard to the Succession Act, with regard to the property, with regard to the legal heir after the death of the deceased. And in case of private injury, private wrong. But my case is not with regard to the Succession Act, property dispute, or other aspects which has been discussed in this case, Lordship. My case is there are 10 prayers. Only one prayer is with regard to the compensation. There are other 9 prayers in the writ petition, and this writ petition has been filed during the
So
lifetime of
who was tortured?
the writ petitioner,
No. The dead writ petition.
dead writ petitioner, yes, Lordship. And the Lordship kindly,
So it is with him, it has died.
no, that
Yes.
law is not applicable in this case, Lordship.
Why?
Because the fundamental right has been violated, and
Fundamental right of whose have been violated?
fundamental
Whose fundamental right has been violated?
of the dead petitioner. And
So for dead fundamental persons, fundamental right of a dead petitioner, this court is going to pass an order.
violation of fundamental rights not come into the purview of private wrong. It is public wrong against the public. The violation of this assault during custody, it has been admitted, it has been proved, that has not been denied.
But that did not lead to his death.
Yes, Lordship, that is true. And this petition has been filed during his lifetime, not the wife has come into his shoes to file this application,
Understood.
Lordship.
Therefore, the moment he died, cause of action is
No,
ceased.
that is in connection with private wrong, Lordship. That is private injury. This is public wrong committed by a public officer in connivance with public authority, Lordship. The difference between public wrong and private wrong, this law is related to public wrong, as per my limited understanding, Lordship.
Okay, show me a principle of law laid down by the Supreme
Yes, Lordship,
Court.
my affidavit in reply, Lordship, kindly peruse.
Well, what does he say? Yes.
First, Lordship, my prayers in the writ petition.
Yes.
First prayer was to set aside,
First prayer has gone.
has gone. Assam Human Rights Commission has done nothing.
Second prayer set aside and quash the impugn order has gone.
Yes, Lordship. Third is,
Directing the respond number 1 and more particularly the respond number here to pay
this
exemplary
is,
gone.
sure.
Gone. Number 3 is go. Directing so-and-so to initiate departmental inquiry and criminal proceedings against the respond number
With-
7 and 9 for preparing and submitting false reports of the petitioner before the year. So this remains.
Yes, Lordship.
Directing respond number 1 to 4 to initiate immediate departmental inquiry against the respondent number 7-9 for custodial violence meted out to the petitioner.
Yes, with
So this,
nothing has been done with regard to this.
it's okay.
Yes.
So 4 and 5 is there.
Yes,
Okay.
Lordship.
Then direct so-and-so to initiate departmental proceedings against the concerned doctors for preparing and submitting. Concerned doctors meet parties, I suppose. They are parties?
Their Lordship, usually,
No.
no. Medical college was.
So obviously
party.
that cannot happen.
Yes,
Initiate contempt proceedings against so-and-so in view of the violation of so-and-so. That is not possible.
yes,
Direct-
that has already been, done by the trial court, conviction has been done.
So that is a conviction which is pending. That matter is there
Yes,
in appeal.
appeal, it is pending.
Where I'm not concerned. Direct respondent to provide information sought for by the petitioner through his application under the Right to Information
That
Act.
has been,
Obviously, that cannot happen, taking into account that you have an appeal. Impose penalties as laid down in the so-and-so here, this court is not going to do because section 20 you can very well approach the appropriate authorities. This court can't. Direct is to pay to the cost and expenses. That is also not possible.
Yes, sir.
Okay. Now let us see 3, 4, 5.
4 and 5.
4 and 5. Okay.
Yes, sir.
Okay.
Here, sir.
Okay, 4 and 5.
4 and 5.
Now 4 and 5 is on the basis of DK Basu. Isn't it?
Yes, sir.
Yes. If
Now-
it is on the basis of DK Basu, does it say that the person having died, not for any other reason, the proceedings can be continued? If the person has died on account of that, there's no quarrel. These proceedings could have continued. But that is not the case. The person lived, he filed a writ petition, he had lived for another 4 or 5 years. Thereafter, he died, not on account of the custodial violence which had happened.
Lordship, this,
So therefore, the only way is in both ways. You have to go to the division, either take a dismissal and go to the division bench as a writ appeal, or a PIL direct again to the division bench. This court cannot.
Lordship, this, view of this court, honorable court, is connected with 306 of the Indian Succession Act.
Huh?
This, DK Basu's view, what has been stated by this honorable court, is in connection with 306 of the Indian Succession Act, wherein it has been stated that the person dies and its rights also dies. Now, my case is not connected with this section, Lordship. DK Basu, I am relying on one paragraph. If court permits, Lordship, kindly
Madam.
permit me to.
Madam, kindly listen. The principle that a person died with his, any personal action of his dies with him is a universal law. Exceptions are being created. What are the exceptions? Exceptions are the Fatal Accidents Act, the Motor Vehicles Accidents Act, Indian Succession Act. 306 creates an exception. You think that 306 bars? No. 306 creates an exception. That is why I asked you to read paragraph 64. Paragraph 64 says that these are the sections which creates an exception. These are the provisions. So therefore, this is a universal law that a person with him, any personal right or any personal right to him cannot further proceed, cannot be agitated by anybody. But there are exceptions. One is the Fatal Accidents Act, Indian Succession Act 306. And therefore, you see the provision of Order 22, Rule 2, Order 22, Rule 4. It categorically mentions about right to sue. Your writing down would not do it. Now the matter finishes today. The matter has to be done and dusted by 11 o'clock with the dictation.
But Lordship, I have to make my submission here.
Heard
Lordship,
completely.
Lordship, kindly
No.
allow me to submit. Lordship, DK Basu, Lordship is saying about.
DK Basu is for-
Now, Lordship,
You see, I have not been able to understand the concept of DK Basu to be applicable after the death of that particular person, unless that was the cause of the death. Very difficult for me. You need 2 judges. Division bench.
Basu, kindly permit me to submit.
I've
Lordship.
heard you.
No, Lordship,
I've
I
been
have
continuing
to
with this
submit
matter for a
on
long
the-
time.
Lordship, on the basis of their reply, they have filed. I have to submit, Lordship.
Please submit.
In additional affidavit, they have filed. Not additional affidavit in opposition, they have filed February 2026. They have bring on all material record which supported the case of the petitioner that it is a case of assault during police custody. And Lordship is again put question that it is a private wrong, private injury. Now, Lordship, with regard to that, I pray to allow me to read one paragraph first from D.K. Basu. The claim in public law for compensation for unconstitutional deprivation of fundamental right to life and liberty, the protection of which is guaranteed under the Constitution, is a claim based on strict liability and is in addition to the claim available in private law for damages of tortious acts of public servants. Public law proceedings serve a different purpose than the private law proceedings. Award of compensation for established infringement of indivisible rights guaranteed under Article 21 of the Constitution is a remedy available in public law. Since the purpose of public law is not only to civilize public power, but also to assure the citizens that they live under a legal system wherein their rights and interests shall be protected and preserved. Grant of compensation in proceedings under Article 32 or 226 of the Constitution of India for the established violation or the fundamental rights guaranteed under Article 21 is an exercise of the courts under the public law jurisdiction for penalizing the wrongdoer. Whether this honorable court under 226 will see the admitted wrong committed by the respondent authorities. Only on the question
Whom?
that under
Wrong committed upon whom?
committed by respondent number 7 and
Upon whom?
upon whom the deceased Lordship, I am trying to Lordship, this violation is not a private violation, private injury. So fundamental rights violation by a public officer along with the public authorities amounts to violation of Article 21 and it comes into the
Article
violation
21 of
of public
whose?
law.
Whose
So
Article
then
21?
all violations, all the riots, all has been comes into the personal law. Then the state will not do anything. Similar paragraph, Lordship. Another judgment, Lordship, I am relying on Somnath versus State of Maharashtra, Lordship, paragraph 21. Kindly allow me to read, Lordship. Having considered the facts and circumstances of the case, this court
Have you
finds-
filed reply to Madam?
Yes, Lordship. Yes, I have filed and I have categorically replied all the statements. They have denied, only denial, nothing on record to show that they have not committed custodial violence upon the deceased husband of the petitioner, Lordship. There is nothing on record and they have supported our case. And only question is, only the queries made by this honorable court is their defense that the petition is not maintainable as the petitioner was died. That is with regard to the personal wrong and personal injury committed on a person. And this is a public wrong committed by the in violation of constitution, constitutional law. So it is comes into the public law. The public law, this honorable court has ample power to make any appropriate order to tackle this type of incidents.
At whose instance?
Lordship?
At whose instance? Of a dead person?
Yes, Lordship.
No.
Crime doesn't lie, died along with the person, Lordship. This is a crime against humanity and public law, Lordship. So this cannot be died with the person who suffered this violation. Provided the protection has been provided by the Constitution and this has been violated by these persons. So, Lordship, it is not come into the private injury and private law. This is my humble assumption and I want to read another paragraph of another judgment, Lordship, paragraph 21. I have quoted in this reply, Lordship. Having considered the facts and circumstances of the case, this court finds that there is enough material to indicate that respondent number 2 did commit excesses against the appellant, as the same has also been found in an inquiry by the commission, as also relied upon by the High Court, and such finding has not been varied or interfered with. Thus, the court has no hesitation in strongly denouncing such high-handed action of the respondent number 2, who being in a position of power, totally abused his official position. However, in view of the fact that the respondent number 2 has superannuated and during the course of present proceeding, 1 lakh apart from what was ordered by the High Court has also been paid by the respondent from his own pocket to the appellant, which the appellant accepted. The court finds that the matter now requires to be finally given a quitus. Be it stated herein that so and so as ordered by commission will only add the power of High Court under Article 226 of India to award compensation is undoubtable. Reference wherein can be made in Nilavati Bera has been relied upon in this paragraph also. There is another Nilavati Bera reference has been made.
So Nilavati
Nilavati
Behera,
Behera,
who was the petitioner?
Petitioner was the husband of this present petitioner.
Nilavati Behera. What are the facts of Nilavati Behera?
Nilavati Bera custodial death, lordship, but
Saved,
the overall
saved,
regarding violation has
saved by the fatal accident.
but all law has been described in
saved.
connection with assault. It has said death and custodial violence.
So therefore, you should have put it on affidavit that this was the person who have suffered out there. The person has suffered out of that trauma. He died after 4 years. Yes, you have a case. That's not a case. And therefore, your right to sue continues.
No, case, lordship, case is filed during his lifetime. Case is on, lordship. This is not the case is abated. Rightfully, the wife has been substituted on his behalf. And there are the prayers, another judgment.
That is why this judgment also categorically mentions out there that the court should be careful while substituting, exercising to Order 22 Rule 2 and Order 22 Rule 4. It has to be in the premises of Section 306. That is this judgment.
Then the respondent has to challenge that order, lordship.
Which one?
The substitution order, they have to challenge. The petitioner was substituted on behalf of his dead husband, lordship. And they have not challenged till today, 26. Now, lordship, on that basis, the whole writ petition, not the petitioner not only come for compensation. See, the petitioner was before this court
No,
for
madam,
violation of fundamental
The
rights.
lack of knowledge of the counsel who represents the respondents in that matter,
Yes, lordship.
or the
They have
lack
not
of
been
knowledge of
lordship,
the court to the provisions of applying Order 22 Rule 2 and Order 22 Rule 4. Can it be a ground for this court to be bound by that order and completely shutting out the eyes in respect to 306?
as they have not challenged, as the other respondents has not made any claim or any submission with regard to that order or the maintainability of this order. Only respondent number 7 has come up. Where is other respondents, state authorities? They have not filed any response. What is their stand? They have admitted or disagreed with the claim of the petitioner, the violence committed by
Let
their
us
official.
therefore see, let us assume everything to be correct, but can you get us a relief out here?
Yes,
Being the
court,
wife, no,
court has the power, lordship.
I don't have the power.
Court has to.
So therefore I say this power, you are just limiting this court to make the judgment as shorter, because I'm going to finish it at 11. The judgment will be done and dusted at 11. So therefore, whatever may be, you are only, okay, it will be your advantage, taking into account the shorter the judgment, the reasons becomes more cryptic, and that will give you a good ground for you to appear before the division bench and explain it to the two judges. For me, it is to be finished by 11. So let me dictate.
So my submission and my
Consider your
argument is-
submission. But you don't satisfy this court on the basis of how you could continue the present proceedings. If you had died on account of anything of that, then obviously you had a case. So therefore, when I asked her to file a particular affidavit in that regard, I also said that finally your reply.
Lordship, if I die with regard to my property, my legal heir can claim.
Huh?
But if my personal.
Because the property, your property by law is heritable in terms of if you are a Hindu succession act. If you are Muslim, then the Muslim laws, or if you are a Christian, by Indian succession act. That is how it happens. You need laws. Otherwise, the principle, the universal principle applies.
That universal principle with humble submission is not applicable with this case. This is not, I am saying, Lordship, the fundamental rights has been violated. Fundamental rights is not comes into the parameter of public injury or private injury. 306 is with regard to public injury, private injury. This is public wrong. Commission of offense, violation of
Let me
fundamental
tell
rights.
you, you
This is
appear for the BTC. A person appears and asks for promotion. He was not granted the promotion. Okay? So he files a petition. He dies. Can he be substituted by his wife? Can he be?
That is, Lordship,
Same principle.
not
That
pub-
is also fundamental violation of Article 14 and 16 of the Constitution. Are you saying that 21 is
20
much better?
yes, must
21 is different.
to life.
Right to
Without
life is
considering
different from
the
Article 14.
Established law of the land. That is the
So
difference
what?
of 14 and
For that,
21.
contempt is there.
Contempt was filed, that was closed because the criminal proceeding was pending.
Okay, enough. Heard Ms. N. Chaudhary, the learned counsel appearing on behalf of the petitioner. Mr. D. Nath appears on learned senior government advocate appears on behalf of the respondent number 1, 2, 4, 5, 6. Ms. S. Sharma appears for respondent number 3 and 10. Mr. H.K. Das, the learned senior counsel, assisted by so-and-so, appears on behalf of the respondent number 11, 12, 13. Human rights. Mrs. M. Hazurika, the learned senior counsel, assisted by so-and-so, appears for respondent number 7. The present petition has been filed by the petitioner. Was filed by one, Gurmeet Singh, bracket since deceased. Seeking the following reliefs, which are reproduced herein under page 31 of this. The aforementioned reliefs were sought for by late Gurmeet Singh, by filing the writ petition on the basis that the private respondents herein, upon the remand being granted, administered third-degree torture when late Gurmit Singh was in police custody. Which was in violation to the law laid down by the Supreme Court in the case of D.K. Basu versus State of West Bengal and others, reported in 1997, 1 SEC 416. It is further relevant to take note of that on account of the torture meted out to late Gurmit Singh while he was in custody, a criminal proceedings were initiated against the respondent number 7, 8, and 9. Trina, and the said proceedings respondent number 7, 8, and 9. Under sections, Madam?
330, 326,
Hmm?
330, 326.
Where do I get the judgment? Is the judgment passed now? Huh? Page? Page 7. Ah.
326.
Under section 326, 331, 34 of the Indian Penal Code. The said proceedings, criminal proceedings, where was registered and numbered as CR case number 3451C/2013. While the said proceedings were going on, late Gurmeet Singh filed the present petition seeking for the various directions as have been aforenoted. Unfortunately, when did he die? Hmm?
28/11/2018.
Huh?
28/11/2018.
28/11, before the judgment.
2018.
While the said instant petition was pending, the learned court of the additional session judge, number 1, Kamrup Metro at Gauhati, convicted the respondent number 7 by the judgment dated 21/6/2018 and sentenced the respondent number 7 to undergo rigorous imprisonment for 2 years and to pay a fine of ₹50,000. And in default, to undergo rigorous imprisonment for 3 months. An appeal thereagainst was also filed by the respondent number 7 before this court, which have been registered and numbered as criminal appeal number 198/2018. The appeal have been admitted by an order dated 2/7/2018 and is presently pending. Next. Unfortunately, late Gurmeet Singh expired on so-and-so. Where's the date?
28/11/2018.
28/11/2018. The records further reveal
On March 20.
that on an application filed in the year 2022, by the wife of late Gurmeet Singh, which was registered and numbered as IA civil number 508/2022, The learned coordinate bench of this court substituted late Gurmeet Singh substituted the wife of late Gurmeet Singh, the present petitioner. Before proceeding further, this court finds it very pertinent to take note of a relevant relevant fact. There is an application where you have sought for judicial inquiry. Huh?
Prayer regarding judicial inquiry.
There is. You could see somewhere. You didn't ask for judicial inquiry,
Yes, Lordship, there is.
huh?
Human Rights Commission.
Human Rights Commission is okay, but Human Rights Commission application was filed by her.
By her.
If it was filed by her, then it was not filed by the this person concerned.
At the time, he was in judicial custody.
Understood. So if it was the Human Rights Commission was filed by, there are two applications which have been filed by his, by the wife.
For Human Rights and Police Accountability Commission.
Huh?
Police Accountability Commission she filed and before Human Rights Authority.
This Accountability Commission, it is functioning. Is it of any use? No use.
Human Rights Commission, Lordship, they have disposed of the matter as criminal proceeding was pending. So
Huh?
they have closed the matter, Human Rights Commission. And Police Accountability, they have not done anything. Lordship.
You have filed the police accountability
Yes, both
Right.
and human rights, nah?
So she accrues the right, Lordship.
Relevant fact to take note of that the wife of the petitioner filed two applications. One before the Police Accountability Commission and other before the Assam Human Rights Commission. Next. Complaining about the torture meted out to her husband and for taking appropriate actions against the concerned police officers. The records further reveal that both the proceedings were dropped.
No, Lordship. As Police Accountability Commission, they have not done any action with regard to that.
The records reveal that the Police Accountability Commission did not take any steps on the complaint filed by the wife of late Gurmeet Singh. And the Assam Human Rights Commission had dropped
Yes.
the said proceedings.
As criminal proceeding was pending before the judicial
On the
officer.
ground that there has been criminal proceedings pending before the competent court of criminal jurisdiction. In the backdrop of the above, this court takes note of an application filed by the respondent number 7 before this court. Application, madam, you have filed an additional affidavit or application? Filed an additional affidavit. Before this court, raising the question of the maintainability of the petition on the ground that on the principles of actio personalis moritor cum persona, meaning thereby a cause of action which is personal to a person dies with his death. It is the case of the respondent number 7 that the reliefs which have been sought for in the instant proceedings cannot be granted inasmuch as the reliefs which have been sought cannot be granted upon the death of late Gurmeet Singh. Inasmuch as the reliefs so sought for were personal to late Gurmeet Singh, and are not saved by any statutory enactment or for the purpose under Section 306 of the Indian Succession Act, 1925. A reply there against have been filed by the petitioner, by the present petitioner, stating in the alia that it is not a personal wrong which was caused to late Gurmeet Singh during his lifetime. It was a constitutional infraction thereby violating the mandate of Article 21 of the Constitution. As have been laid down by the Supreme Court in the case of D.K. Basu Sukra. It is also mentioned, contended by the petitioner, by the present petitioner, as the wrong which have been committed upon late Gurmeet Singh was a public wrong. The said cannot come to an end with the death of late Gurmeet Singh. This court have heard the learned counsels appearing on behalf of the parties and have duly taken note the reliefs which have been sought for. By the original petitioner in the instant proceedings. It is pertinent to take note of that the incident complained of was sometime in the year 2013. And thereupon the present petition was filed in the year 2014. The materials on record do not show or for that matter, the present petitioner have not placed any material which would show that on account of the torture, alleged torture committed by the private respondents, it led to the death of late Gurpreet Singh. The torture, alleged torture which was meted out upon late Gurpreet Singh was personal to late Gurpreet Singh. Though it violated, though if true, it violated the fundamental rights of late Gurpreet Singh under Article 21 of the Constitution. It is the opinion of this court that in the present circumstances, the principles of actus personalis moritor cum persona would apply. First, the death of late Gurpreet Singh cannot be traced to the alleged incident of torture. And under such circumstances, the exceptions culled out by the Fatal Accidents Act 1885, the Legal Representative Suits Act 1885, as well as the Indian Succession Act 1925, etc., cannot be applied for permitting the wife of the petitioner, of late Gurpreet Singh, who is the present petitioner, to continue with the present proceedings. This court finds it this court finds it profitable at this stage to refer to a recent judgment of the Supreme Court in the case of Kumudlal versus Suresh Chandra Roy dead through LRs and others, reported in 2026 INSC 443, wherein the Supreme Court culled out the principles as to when a right to sue survives. Paragraph number 59, 60, 61, 62, 63, 64. being relevant are reproduced hereunder. Under such circumstances, it is the opinion of this court, in view of the principles of law laid down by the Supreme Court herein above, as quoted herein above, the present petition cannot be proceeded with at the instance of the substituted petitioner, that is the present petitioner. And accordingly, this court dismisses the instant petition. Before parting with the record, this court, however, finds it very pertinent to observe that the present petitioner, on her own, submitted applications before the Police Accountability Commission, as well as the Assam Human Rights Commission. The Police Accountability Commission did not take any steps in pursuance to the applications filed by the present petitioner. And the Assam Human Rights Commission dropped the proceedings on the ground of pendency of the criminal proceedings. These applications which were filed by the present petitioner are independent of the cause of action which accrued upon her husband, that is late Gurpreet Singh. Under such circumstances, divorce the dismissal of the present petition, it shall not bar the petitioner to approach the Police Accountability Commission in furtherance to the earlier application so filed, and further to the Assam Human Rights Commission if there is a Assam Human Rights Commission subject to the, which should be subject to the outcome of the criminal appeal presently pending. It is observed that in terms with the leave, if the concerned authorities, that is the Assam Police Accountability Commission, as well as the Assam Human Rights Commission, do not act, it shall not be a bar for the petitioner to again approach this court. You got it? But this is the principle. Yes, what has happened? Anything? When you are taking it?
We have already sent to the higher authority, my lord, but there is no instruction.
But the fact remains one thing. No, there cannot be a no instruction.
Yes, my lord.
Madam, You cannot come up before this court and say that there is no instruction.
Well, no
That is
instruction,
a
we have
thing
already
which
sent,
is
my
not
lord. My
going
lord,
to.
we have already sent to the
Either
higher
you
authority.
vacate or bring instructions. I'm not concerned to that effect.
What
You
counsel-
cannot tomorrow
No,
get your instructions or vacate.
tomorrow, my lord.
Tomorrow. This thing cannot happen like this. Don't take it that this court has not asked you.
No, my lord.
You are
We have
in,
already
you
sent,
see,
my lord.
you know that which land it is.
Yes, my lord.
You know you have
Yes,
been
my
in
lord.
possession of the land.
Yes, my lord.
So your acquisition, although now it will happen,
Yes, ma'am.
but date back from that because every time you are delaying it,
Yes, ma'am.
he is losing out.
Yes, ma'am. That's why, my lord, we have already
Giving him
sent.
back his land, his right has been taken.
After verifying
You, who are you? CRP?
CRPF, my lord.
CRPF.
Yes, my lord.
Are you not for the people?
Yes, my lord.
Or are you for having their own personal agenda?
No, no, ma-
It seems you have a personal agenda.
no, my lord.
Then-
There is no personal agenda, my lord. My lord, after verifying
You
all
cannot
this,
do-
we have
keep on doing like
sent
this.
to the higher authority for the
No, I
opinion.
don't understand why your higher authority, if the higher authority doesn't see that there is an urgency to the matter.
Yes, my lord. Kindly fix it on first week of June, my lord. I'll take definitely instruction, and otherwise court will pass any order, my lord. On next week, my lord, 5th or 4th of June, my lord. 4th and 5th of June, my lord.
You otherwise get yourself ready to vacate.
Yes, either vacate or, my lord, as per court.
No,
order.
no, you vacate. If
Yes.
you don't
Yes, my lord.
initiate
Yes, my lord.
proceedings, write a letter to the DC
Uh,
to initiate proceedings for land acquisition,
Yes, my lord.
you vacate.
Yes,
Isn't it? It is clear and found.
yes, my lord. Yes, my lord.
He will take it out. That land has been shown to him, and this land will be taken over, and thereupon here. And we will ask the police also to help you, and you vacate.
Yes,
Or otherwise ask that particular person to be present. Next.
yes, my lord.
This is not done. What
Yes.
does he think? The matter of 2014, it is going like this. No. Miss Aga and the learned CCC appearing on behalf of the Army or
CRPF.
CRPF authorities have sought for time on the ground that there is no instructions available from the higher authorities. It shocks and surprises this court. Now, this court is shocked and surprised with such submissions, taking into account that when the instant petition has been pending and this court have been passing various directions from time to time, the manner in which the CRPF authorities are taking up the issue. It appears, therefore, the actions on either the CRPF authorities do not believe in the rule of law, or even the provisions of the Constitution. Taking into account the laxity in which the CRP authorities are taking up, and taking into account the laxity in which the CRP authorities are taking up the instant proceedings lightly, it is the opinion of this court that certain stringent directions are required to be passed. However, at the request of Ms. Aga and the learned CCC, this court restrains itself from passing any such directions today. However, in the eventuality that on the next date positive instructions are not placed, this court would be constrained to pass appropriate directions. lists this matter on 9/6/2026 at 10:30 a.m. at the top of the list.
Master placement.
Here. DP Bora. Another one.
See, Mr. Dipara is on legs in court number 6.
We don't require him. We put your name. Anyway, he's already a blacklisted counsel. So you are there, put your name, then it will be better. Huh? Allowing the retribution at the instance of a proper counsel. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. N.N. Upadhyay.
N. Upadhyay.
N. Upadhyay, the learned counsel appears, the learned standing counsel of the irrigation department. The petitioner herein had approached this court, being aggrieved by the action on the part of the executive engineer in not providing the site verification certificate which the petitioner applied on 1/4/2026, and resultantly the petitioner could not submit the bid. The brief facts which led to the filing of the present petition is that a notice inviting tender was issued on 13/3/2026 by the Chief Engineer, Minor Irrigation Assam, for remodeling and improvement of Behali FIS and SOPD-G for the year 2025-26 under Biswanath Behali Division (1) Biswanath Sariali. In terms with the said notice inviting tender, the schedule was clearly mentioned. The time schedule was clearly mentioned. The bid submission start date was on 23/2026 and the bid submission end date was on 4/4/2026. In terms with clause 6 of the said notice inviting tender, there was a requirement of submission of a site visit certificate by the bidder. Clause 6 of the said notice inviting tender being relevant is reproduced herein under page 26 of this. The petitioner submitted an application on 1/4/2026 to the respondent number 3 for the purpose of issuance of the said site visit certificate. So it may not be out of place to mention that the present notice inviting tender was a retender, inasmuch as in the earlier tender, the petitioner had visited the site, had submitted his bid, its bid, and was declared to be L1, but later on, the tender was cancelled. Resultantly, the present notice inviting tender was issued. Next. The respondent number 3, for reasons best known, did not provide the site visit certificate. Resultantly, the petitioner could not participate, for which he approached this court by filing the present writ
So
petition.
in fact, I have stated by affidavit, Lordship, why it could not be issued to the
I know
petitioner,
that.
Lordship, paragraph 5 of my affidavit, Lordship.
Let me come back
Lordship,
to his facts.
Lordship.
The record reveals that this court, by an order dated 7/4/2026, issued notice. Subsequent thereto, when the matter was listed before this court on 29/4/2026, this court directed the petitioner to file an additional affidavit bringing on records that he had participated in the earlier tender in respect to the same work and had a site visit certificate. This court also passed an interim direction that the respondent authorities should not open the technical bids in respect to the tender dated 13/3/2026 till 6/5/2026, which was the next date fixed in the present proceedings. The record reveals that an affidavit has been filed by the respondent number 3. At paragraph number 5, the reasons have been assigned as to why the petitioner had not been issued the site visit certificate. It was mentioned that it was admitted that the petitioner approached the office of the respondent number 3 for the site visit certificate on 1/4/2026. However, during that relevant period, the executive engineer, that is the respondent number 3, the section assistant, the site in charge, as well as the concerned assistant executive engineer of the respective subdivision were engaged in duties relating to the Assam Legislative Assembly election, which was scheduled to be held on 9/4/2026. It was under such circumstances the site visit certificate could not be issued. It was also mentioned that had the petitioner approached earlier, the site visit certificate could have been issued. This court, from the aforesaid statements made in paragraph number 5, it is therefore clear that the petitioner duly applied for the site visit certificate well prior to the last date of submission of the bid. And on account of difficulties on the part of the respondent number 3 and the irrigation department, the site visit certificate was not issued. This court also takes note of that a perusal of clause 6 makes it mandatory that the site visit certificate has to be submitted along with the bid. And this aspect would be apparent from a perusal of clause 10, 11A, capital A. Where is that site visit certificate?
Page 26.
Page 26.
Now that I know. Now where it is said that it is required? Now there is the one thing, no, it is always given. Well, You don't have a clause like PWD, which says that about the site visit certificate. Which is very much apparent from a perusal of clause 6 as quoted herein above. Taking into account the aforesaid facts, it is the opinion of this court that the respondent number 3, having not issued the site visit certificate to the petitioner, after the petitioner had applied within the period prescribed for the last date of submission of the bid, the petitioner was debarred from submitting the bid by the respondent number 3 as well as the irrigation department, as well as other officials of the irrigation department. Under such circumstances, the act on the part of the irrigation department to proceed with the tender in question violates the mandate of fairness, reasonableness, as well as fairness and reasonableness, and the equality clause enshrined in Article 14 of the Constitution. Accordingly, this court therefore sets aside the entire tender bid process initiated on the basis of the notice inviting tender dated 13/3/2026 with liberty to the respondent authorities to proceed with fresh bidding by issuance of a fresh notice inviting tender. The writ petitions therefore stands disposed of with the following observations and directions. The action on the part of the respondent authorities in not providing the site visit certificate to the petitioner, which barred the petitioner to apply in pursuance to the notice inviting tender dated 13/3/2026, is in violation to Article 14 of the Constitution. Number 2. The tender process so initiated on the basis of the notice inviting tender dated 13/3/2026 is therefore stands interfered with. Number 3. The respondent authority shall be at liberty to proceed with the work, proceed to initiate, invite fresh tender proceeding, proceed to carry out the work by inviting a fresh notice inviting tender, if so advised. You want your name.
What they have brought in. Advadi Nirvai case, my lord, 125H. Provision of vehicle location track device emergency button. All public service vehicles defined the article clause 35 of section 2 shall be equipped or fitted with a vehicle location tracking device and one or more emergency button, provided these rules shall not apply. Number 2, specification testing. Certification of vehicle location tracking device emergency button referred to in sub-rule 1 shall be in accordance with AIS 140/216 as amended time to time till such time so and so. Number 3 is important. The vehicle location tracking device and emergency button referred to in sub-rule 1 shall be fitted by the manufacturer or the dealer or the respective operator as may be in accordance with so and so as amended from time to time, so and so, so and so. So now, if your lordship please turn to page 44, there, page 44, this is the notification which has been issued, my lord, by a statutory order at page 44. Please see, my lord. Now, therefore, in exercise of power conferred under subsection 3 of so and so, central government here make the following order to specify such standard, namely so and so. Number 3, my lord, this order shall apply to all public service vehicles specified in so 125H. The overall 4 approach for installation of so and so on public shall be as follows. A, the VLT device manual shall get the device tested and certified from any of the testing agency referred to in Rule 126 of the Central Motor Vehicle Rules 1989. Number B, state or union territory shall ensure compliance to Rule 125H so and so and check fitment and functional status in the public service at the time of checking of vehicle for fitness certificate. Now, this is the only role of the state. Our case is that under central legislation, 125 has been amended, my lord, and it says that all public vehicles, they should come with this device after the Nirvaya case, and there will be a press button. Now, there are certain vehicles, my lord, these are fitted, all these vehicles, certain vehicles, and which are not fitted, it is given the choice of the, now please see, C is very important. C at page 44, my lord. C. Kindly see, my lord. The public service vehicle owner shall have freedom to choose or install the VLT device of its choice from any of the manufacturer so long as it is type approved as per Central Motor Vehicle Rule 1989. So, our company is to read petition before this honorable court. These are the manufacturer of this this device. Accordingly, my lord, under 126 it was tested as per the Central Vehicle Legislation, and we have got the license. Now after that, it has to be uploaded more in the behind this device is uploaded, and it has a cross check with the testing agencies, my lord. Thereafter, there is another procedure, my lord. Now this state, there are a lot of funds has been given to the state. It has not started operation in the state of Assam, but there are other states which has already started operating this. Till you don't operate, there is a software and a mechanism which is NIC. So we have to register that also. We smile on a live location, it is being tracked by them. All we have. Now what we are saying, that these are, my lord, a central legislation which has been made, and statutory order has been passed under the rules, and it has given free choice to the public that they can choose the manufacturer or a dealer. In pursuant in this the term, the law which has been laid down, now the state government has come into an UI. My lord, their role is very limited. Their role, I have said, my lord, what is the role it has been listed? What is their role? It is only that software, they will prepare the software, tracking backend. Backend is there. So their role is up and fitness. Every year they will check it whether the fitness certificate has to be given. Now, what they have done, how we are aggrieved? We are aggrieved by an impugn order that has been passed by an EOI at page 104, my lord. EOI at page 104, which have been issued on 13/3, but my lord, this terms and condition was on 5/5/2026. Now, my lord, before I read that, why I am aggrieved by that, they said that if you have anything grievance, you can put forward a repetition. Accordingly, we represented to them, my lord. of fleet we have represented, and there is no reply which has come from them. Now, my lord, will please see the page 126, my lord. 104 is the UI. Please 126 clause 3.1. 126. They are asking for empanelment, my lord. There we have to empanel. These all the manufacturers, they have to empanel under them, my lord. No empanelment, you are out. Now please see 126, my lord. Yes. Please see 126 clause 3.1. Applicant manufacturer should be a registered company so and so and so and so. The applicants have been in existence for not less than 5 years. Now, my lord, 127, please see 3.3. It has not started in this state. 3.3. VLT device model which manufacturer intend to submit for registration must submit conformity of production from MOT approving agency. My lord, MOT is type approval. Now conformity of production will come later on, my lord, after a year, conformity of production. Now, my lord, there are few states which they are operating, 1 or 2 states operating. For this state is a very new state, which this is a state which will operate now, my lord. But till then, my lord, what I said, NIC controls it, my lord. Now, my lord, will kindly see 3.6. The VLTT manufacturer should have registered with Department of Telecommunication to operate as a machine-to-machine service provider. 3.7, manufacturer must have a minimum of 3 years of experience in the manufacturing of AIC, AIS 140 compliant VLT device. VLT device model name and model number, part number specified should be clearly and permanently inscribed on so and so. Now 3.12. The VLT manufacturer must have cumulative turnover business in India at least 25 crore in the last 3 completed financial year with positive net worth. Manufacturer must appoint 3.13. Must appoint as authorized super stockist or distributor who holds a valid GST registration so and so. Now, why I am agreed, my lord, because I have shown, my lord, in view of this statutory order that has been passed by the central government, they said that you can pick, it's up to you, you can choose.
No.
Yes.
Just for example, any public bus, a public bus may be owned by anybody else. Any person may own it. Now, if it is a public transport vehicle, it is owned by the transport department.
Yes.
They are asking for empanelment. Thereby, once you are empaneled, then they will be awarding contracts on the basis of a rate. A rate contracts comes into being. Now, what does 125.8 say? 125.8 says that there is a requirement of having a VLT device in those vehicles which have been mentioned in 125H1.
Yes.
Exceptions are given to ABCD. Now it further says that this particular device concern has to be in compliance to 126.
Correct.
And that means the MOT has to approve the prototype.
Yes. It is approved. It is there.
Approved. So MOT would not approve the prototype without the confirmation.
Yes.
Correct. So MOT has done it.
Yes, it is.
Now,
Mike has done it.
You are referring to this order. Order says yes. Just for example, any transport vehicle, private, a public vehicle, because you see there is a difference. 125.8 says about public vehicle, whereas this EOA is for public transport vehicle. Public transport vehicle is under the transport department only, isn't it?
No, it includes the private also, my lord. Private taxi also. Private taxi. No, my lord, your lordship is, if it is a public transport, is includes the public way, the private vehicles also, ma'am. Two 35, my lord.
This is public service vehicles.
Yes, yes. right.
Public service vehicles. Public service vehicle is defined in 235.
Yes.
Means
Public
any
means
motor
any motor
vehicle
vehicle.
used or adapted to be used for the carriage of payer for hire or reward and includes the
Yes.
maxi cabs and so and so.
Yeah.
So it will include everything.
So that's why
But
I'm
if it
saying-
is a private public transport vehicle, it will be only limited to them. They are only asking, we will be using for public transport vehicle is only limited to them. It would
I
not
don't
apply
know
for
any
the.
of those. That's why public transport is they can, but not my lord, there's commercial vehicles.
The commercial vehicle, they cannot.
No, that's why that's the whole
Because the
problem.
moment they are saying in respect to commercial vehicle anything, then it will violate that because then anybody may have a right. to
That's
what
not
VLT
case, my-
device they want to put. Because the VLT device are to be put either by the manufacturer or the what?
It may be retrofitted, my lord. Retrofit. But if it is, if there's
If
a
it is-
vehicle.
No. There are three persons who can do it. It is given here.
Dealer, authorized dealer, manufacturer, my lord.
Manufacturer or their dealer.
Yes.
Just for example, Maruti can do it. Then Vimal can do it. And respective operator can do it. So, as the case may be, shall be fitted by respective operator. Respective operator must have been defined somewhere. So they can do it. So if you are selling a maxi cab, now new one, just for example, new one, they will be doing it. The manufacturer will be doing it on its own because this is now the mandate. But as regards to own vehicles, where there is a permit required, then the question will arise is because those persons concerned, they may choose because this is permissible. But if it is a public transport vehicle, that is those which will be coming under the transport department, there you can have your own terms and conditions.
Well,
but you cannot impose that these EOI shall be have any relevance with others.
My lord, I'll need to take instructions, my lord, the short date. However, my lord, there's a clarifications that was given by the transport department on the EOI, my lord. It's
They
an
didn't
annexure
answer to
15.
our query. My lord, your lordship is a problem. Transport, absolutely no problem. But so far as the vehicles, other vehicles are
No, then
concerned.
you are not concerned.
No. My lord, we have,
No, then you cannot have any concern with this EOI.
know what? Yes, my lord, what we have written to them. We said specifically this query has been put forward. You cannot restrict so far as
Have they answered to that? No.
no answer. That's the whole answer.
Now, have
Generally,
you submitted your bid?
yes.
No, obviously they cannot because that will go against it.
My lord, may come to the clarifications that have been given, my lord,
Where?
for making these extra conditions. Page 180, my lord. It's in the petition. 180.
My lord, can your lordship looks at page 113, my lord, 113. 113, scope of the project, 113.
Yes.
See, my lord, page, scope of the project, 2.1. The EOI pertains to all public service vehicle as defined under clause 35 of section 2 of the motor vehicle act, as well as category of vehicle defined under rule 125 is 90 and 129 of which include buses like educational institution, buses, stages, contract carriage, all India tourist permit, private, all type of taxis, all India like maxi cabs, motor cabs, omnibus, ambulances, vehicle of so and so, number F, all goods carriers including water tanks, G, all vehicle to which national permit are issued, number J, H is so and so. I might file repentation at page 174, my lord. They have not answered my query at page 174. Other bidders, they have answered.
No, here UI for what? What is the UI for?
Here, UI,
All the above vehicles specified in clause 2.1 shall be equipped with so and so. That is okay.
yes.
The government may exclude or include any type of vehicle so and so in according with extent. The covered vehicle should be tagged with so and so, so and so. But why this EOI for?
For empanelment of empanelment of manufacturers who are manufacturing the VLT device.
So therefore, for empanelment, why do you want to empanel?
My lord, may see the clarifications. I'll need to take specific
yes.
instructions, my lord. My lord may come to page 180. My lord, after 11, the next one, my lord, query regarding multiple years of COP requirement. My lord, may see it is intended to evaluate and ensure operational reliability, supply chain stability, and long-term installation maintenance capability of the manufacturer within real-world public transport ecosystem. Experience from several states has indicated that a large number of non-serious VLTD manufacturers participated in the empanelment process, supplied devices, and subsequently exited the state without providing adequate after-sales services and technical support. This resulted in serious implementation challenges, leaving the general public with substandard and non-functional devices, and thereby defeating the very objective of the project. Several states have reported experiencing situations where more than 50% of the installed devices became non-functional or remained inactive for prolonged periods due to inadequate maintenance support, lack of service infrastructure, poor device quality, and absence of accountability mechanisms on the part of the suppliers. Therefore, it is essential to assess the technical credibility, field performance, service network, and long-term commitment of participating manufacturers before empanelment. Since the requirement is for safety of the vehicles, the department has seen that.
So are you saying, let us see, say one. There might be a permit of a bus being given, which may have in Gauhati, in Assam, and Mizoram. Let us take, for example, Mizoram, if it allows a VLT device of a particular standard, you are not going to accept it here. They allow the car to drive, the vehicle to drive out here, if it is not empaneled under you.
But the fitness certificate has to be then given by the Mizoram registering authority.
So if the Mizoram registering authority gives it, you will be accepting it.
But if they give it, they can operate here, but the vehicle would still be tracked by the Mizoram government. That's why the back end is all operated state-wise. My learned senior counsel has also stated, it is all the back end is all done state-wise, my lord.
Okay.
The tracking would be done state-wise. So my lord, since the
So therefore, these VLT devices cannot be there in open market.
But what is happening now is that it is there in open market, but what has been seen is that these VLT devices subsequently stop working and the manufacturers exit the business.
Understood. That is okay. I'm not on that. But you see, the reason for empanelment, normally why do you empanel? Means, are you saying that it is only these devices which will be allowed to sell in Assam?
For,
Huh?
for public service vehicles, once it is empaneled, they will have a
You
choice.
don't require for anybody else.
Well, somebody else might want it, my lord, but
My question is, you don't require the public service vehicle for any other purpose. So you only require for public service vehicle of all public service vehicle will come under it because it is under 235. If you see 125H, it says public service vehicle.
my lord.
So once it is public service vehicle, are you saying that if there is an empanelment, unless you have yourself empaneled, you cannot sell it in the state of Assam?
But perhaps that is the intention, my lord.
No, you
because-
cannot have an intention
Well-
without having it clear.
But I'll have to take the instructions on the specific instructions on
So
that.
then, what do I do?
Well, my lord may see, my senior counsel has stated, my lord, that it is the union government has given certain guidelines. My lord,
Understood.
My lord.
All these guidelines is different. I'm not on that. Now, whether they have those requirements which satisfies the security. This is a more of a security.
securities.
Rather than a safety, it's more of a security.
Well.
Now, whether they have the backhand and all these things, these are things which obviously will be there in the prototype.
Well,
When they do it, when they have the confirmation from the state, national here, what do you call,
can I,
the MOT.
type of proof 126.
Who is appealing for MOT?
This one, we have given.
Mr. Only, you can appear in all methods. You are like our, in Assamese society, you are like dal. It goes with roti, even it goes with rice. So here he can appear for central government as well as the state government. So here, therefore, Mott had come up with all this. Now, see, the state government can only regulate to the extent of looking into the fitness. Only to that extent, if we see this, kindly see this particular page 44. Forty-four. 44B. 44B. The state or the union shall ensure compliance with Rule 125H. Rule 125H says there will be a requirement of a VLT device in all public service vehicles. One. Secondly, it says that this can be either fitted by the manufacturer, the dealer, or the concerned so-and-so. And check fitment and functional status of the VLT. So the implementation is given to the state or the union territories in public service vehicle at the time of checking of the vehicle in the fitness certificate. So you may very well say, you can very well say that these are the requirements for the purpose of fitness. But my question is how there is a question of empanelment. But a selling, can you take up out there that selling in Assam can be only limited to these?
Let me see. In the clarifications, what is stated is that because of technical reasons, they have floated this EOI and it is for ensuring that in the real world compliance of the transport service, it is for the compliance purpose, my lord. We are not deviated from what has been stated by MOD in this SOP or in this notification or 125H. Those minimum qualifications will have to be met, my lord. There's only certain extra, as my senior counsel has stated, there's some extra requirements of 3 years COP. So
No,
that
these are okay.
Well,
That you can very well. For the purpose of how the fitness is to be carried out, is absolutely your domain. There's no quarrel. I'm not on that. My question is, are you saying, because here there are 3 persons who can sell it. manufacturer, dealer. So therefore, Bimal can do it. Maruti can do it. As well as it can be outside also. AGK peers, okay, any three of them. So is the empanelment only for the purpose of checking the fitness, or is it for the purpose of purchasing for or allowing only those to be sold in Assam? My question is that.
But on that, I have to take specific instruction. Yes.
You have submitted your bid?
No, I have not submitted. Why? Because it is, my lord, it is not in consonant because we are the manufacturer. Well, because they are asking for empanelment with all these terms and conditions. 25 crores, 3 years of experience.
Obviously.
No, we are the manufacturer only, my lord. We only where is the question of, first they said get an empanelment. You have to empanel yourself. There is no question of the manufacturer to empanel. It is only to make this device and get it approved by testing agencies and upload through Bahn and the MOT, my lord, which we have done it. And central government has approved, my lord.
No, it's therefore my question is the empanelment for only for the purpose of checking the fitness? My
No,
question is that.
no, my lord. That's
Request for
the-
manufacturer for fitment of ear. Now this is for fitment.
Yes.
So are you therefore having this public transport vehicles only for your transport department? It is okay. Then it's a different aspect. I'm not on that. You may very well say in respect to our vehicles under the transport department or all the government vehicles which are there, which comes under the transport department or the transport vehicles, which are of the nature of public service carriers, there we may have this. There's no problem with that. But are you going to say that nobody can sell it out here?
No, this is what.
My question is that.
My lord, the scope of the work, my lord.
The scope of the work is, seems it has been given in a different manner. It says everything.
Yes, my lord. My lord may, petitioners otherwise may participate. In the meantime, we'll take instructions and file an affidavit. We'll fix a short date.
Today is the last day.
Last date is Friday.
Tomorrow. Well, you participate if you want.
No, but I will be, my lord, there is, because.
If you don't want to participate, that means you don't have a cause of action.
No, if I
You
participate.
are not agree.
No, all these terms and conditions, I don't cover all these terms, 25 crores, 3 years of experience you need, require, my lord. This may be on a public transport, fine, my lord, they can do it. But not only device, my lord, only I make this device.
They are only saying about public transport vehicle.
No. The 113 by 2.1.2.
That is the scope.
No,
But you see
no,
the,
government of Assam.
no, you therefore see the scope. What is being mentioned out here? Request for year for manufacturer of vehicle, location, tracking device for fitment to public transport vehicles.
My lord, please see
This is
121.
not public service device.
Please see 113, my lord.
That I have looked into.
113, 2.1.2.
113 gives
No,
some
2.1.2. Please see 2.1.2. 2.1.2.
may
Government
exclude
of
or
Assam.
include any other types of category of vehicles in accordance with the extent rule. The government, the covered vehicles should be tagged with so and so for certificate of fitness permit so and so, so and so. The owners of the vehicle will purchase here.
Oh my God. So and so upon registered with Transport Commissioner in Assam, my lord.
Huh?
Kindly see the owners of vehicle will purchase so and so, empanel and registered with Transport Commission Assam. Upon insurance compliance will be verified.
What is this SS RFC? What is SSR?
Retrofitment.
From
Retrofitment
purchase
sector.
the way from SSRFC impanel means there is another empanelment.
Yeah.
And registered with the Transport Commissionerate in Assam.
They are restricting the owners of the vehicle.
So you say that there is nothing for you to be empaneled.
And that's what our case is.
So
That's our case.
let them go ahead with the empanelment. You go ahead. But whether that would exclude any right of him, which the subject matter will look into it later on. He did. But as per them, empanelment is not law. Because if you are on the ground of empanelment being not there, if you are restricting their product being sold out here, then it would be a violation of 19(1)(g). So that you need to take care of it.
That's what, that's right.
Because your expression of interest says something else.
Right.
Starting of the is only public transport vehicles. Whereas 125 age is for public service vehicles.
I'll-
247. Where? Transport vehicle. No, this is 247. Transport vehicle means a public service vehicle, a goods carrier, an educational institution, bus or alia. No, this is transport vehicle. Transport vehicle, there is no quarrel. What is public transport vehicle? You see here, if you see the expression of interest, page 104. This is for fitment in public transport vehicle. Now, if it is limited to them, obviously they have the right to do whatever they feel like. If they want these persons out there. But if they want to restrict only to those persons who are empaneled later on and empaneled in respect to all public service vehicle, then the question may come of 19(1)(g). We'll look into it later on. Let's issue a notice on this. Both liquidations, both liquidations. Okay, issue notice making it returnable on after vacation.
That may not give such a long deadline. Before the vacation, we'll file our.
Okay. One thing good about transport department, they are very fast. At the motion stage also, Ms. MD Bora, if she appears, she will always say, my lord will dispose it on. She notice making it returnable on, let's have it on 15th of June. 15th of June, 2026.
Can it be on 18, my lord? It is not inconvenient to your lord. 18.
Why 18th?
Yes.
No 18th, 19th.
Right.
On 19th of June 2026. Mr. K. Gogoi accepts notice on behalf of the respondent numbers 1 and 2, 1, 2, and 3. Mr. So accepts notice on behalf of respondent number 4, 5, and 6. Extra copies of the petition be furnished during the course of the day. The petitioner herein, who is a private limited company, is engaged in the business of manufacturing, supplying, fitting inter alia AIS-140 compliant vehicle location tracking device across India. And such device have been certified by the Automotive Research Association of India, Pune, in an authorized testing and certification agency under Rule 126 of the Central Motor Vehicle Rules 1989, hereinafter referred to as the Rules of 1989. The petitioner had also obtained the type approval certificate. Now, the petitioner also, after obtaining the type approval certificate, had applied to the Ministry of Road Transport and Highways for authenticated access / login in the Bahal portal, which was granted to the petitioner. Pursuant thereto, the petitioner had uploaded the details of the device, that is the make and the model, certificate details, IME number, ICC ID number, etc. The petitioner had also obtained from the Ministry of Road Transport and Highways and National RFC Retrofitment Center to upload the installation and device details in Bahal portal. And presently, petitioner is manufacturing the production of the device. It is seen that in exercise of the powers conferred under the Motor Vehicles Act, the central government had carried out an amendment to the rules of 1989 by the Central Motor Vehicles (28th Amendment) Rules 2016. For short, the amending rules of 2016. These rules came into effect with effect. These rules came into force with effect from 1/4/2018. By these amending rules, Rule 125(H) was inserted to the rules of 1989. In pursuance thereto, to give effect to Rule 125(H), the central government, the Ministry of Road Transport and Highways issued a notification on 25/10/2018, thereby promulgating an order known as the Motor Vehicles (Vehicle Location Tracking Device and Emergency Button) Order 2018. For short, the order. In terms with the said order, which came into force with effect from 25/10/2018, it stipulated the approach for installation of the vehicle location tracking device and emergency button on public service vehicles at clause 4 of the said order. The role of the state government oblique the union territories have been assigned at clause 4, which included the requirement of the state and the union territories ensuring compliance to Rule 125H of the Rules of 1989 and check fitment and functional status of the VLT devices in public service vehicles at the time of checking of the vehicle for fitness certification. It is also seen that command and control centers or such others set up by the state or VLT manufacturers or any other agency authorized by the state government shall be used to provide interface to various stakeholders such as State Emergencies Response Center, the Transport Department or the regional transport offices, Ministry of Road Transport and Highways and its designated agencies, device manufacturers and their authorized dealers, testing agencies, permit holders, etc., as per the practice of AIS 140. Further to that, it is also taken note of that in terms with clause 4J of the order, the state or the union territories are required to publish Internet Protocol address and short message service gateway details of their respective emergency response system where VLT devices shall send the emergency alert on press of the emergency button. Taking into account that these duties, these obligations have been cast by the order dated 25/10/2018, and notice an expression or a request for expression of interest dated 13/3/2026 was sought from the manufacturers of vehicle location tracking devices for fitment to public transport vehicles in Assam. At this stage, it is very pertinent to take note of that the Motor Vehicles Act 1988, though defines the public service vehicle at section 235, bracket 35, and transport vehicle at 2, bracket 47 of the Act of 1988. But there appears to be no definition of the term public transport vehicle. It is further seen, Mr. Didas, the learned senior advocate appearing on behalf of the petitioner, has drawn the attention of the court to the qualification criteria mentioned in the expression of interest to be empaneled for fitment to the public transport vehicle in Assam. The learned counsel the learned senior counsel submitted that these conditions have been inserted which is beyond the purview as well as the powers of the state government to do so. Inasmuch as Rule 125H, inasmuch as neither Rule 125H of the rules of 1989 nor the order dated 25/10/2018 issued by the central government obligates or casts a duty and obligates and empowers the state to put such conditions. The learned senior counsel further submitted that a very perusal of Rule 125H (3) would show that in public service vehicles, the VLTD device could be either fitted by the manufacturer or their dealer or the respective operator. And therefore, if the state respondents are allowed to carry out this empanelment in the manner in which it seeks to do, it would affect the rights of the petitioner, who would not be able to carry out marketing in the state of Assam. The learned senior counsel further, referring to clause 4B, 4C of the order dated 25/10/2018, further submitted that there is a freedom granted to the owner of the public service vehicle as defined in section 235 of the Act of 1988 to choose or install the VLT device of his or her choice from any of the manufacturers as long as it is type approved as per the rules of 1989. The learned senior counsel therefore submitted that no embargo can be put by the state government in selling the VLTD device by the petitioner, inasmuch as the power to restrict is only reserved upon the central government. Anything more?
No.
Okay. Per contra, Mr. So-and-so, the learned counsel appearing on behalf of the Transport Department of the state, submitted that this empanelment is being carried out on account of the experience which is being felt by the state government who are required to carry out the responsibility as enshrined in clause 4 of the order dated 25/10/2018. The learned counsel submitted that the state have reportedly experienced situations where more than 50% of the installed devices become non-functional or remained inactive for prolonged periods due to inadequate maintenance support, lack of service infrastructure, poor device quality, and absence of accountability mechanism on the parts of the supplies. The learned counsel submitted that this is not a case wherein that the very legislative intent to include, to bring in Rule 125H is for the safety and security of the passengers in the public service vehicles. And therefore, for the purpose of carrying out the obligations in terms with clause 4 of the order dated 25/10/2018, scrutinizing and screening the bona fide manufacturer is necessary. Anything more? He, however, submitted that he would obtain instructions as to whether the expression of interest would only include all public service vehicle or limited to the vehicles under the transport department of the government of Assam, inasmuch as the expression of interest mentions about public transport vehicle. This court, having heard the learned counsels, is of the opinion that an affidavit from the Ministry of Road Transport would be necessary apart from the stand which be also placed by the state government. As to whether the state would have the authority and jurisdiction to restrict or to restrict sale of VLTD devices the approval of which lies within the scope and power of the central government. So, taking into account the above, the affidavits be filed on behalf of the respondent, on behalf of the respondents on or before 15th of June 2026 without fail. Well, that either it was an urgency for you to be not there on Friday, or there was no urgency for today. Yes. To be moved on Thursday.
Next case, my lord. Type approval date is 19/12/2025.
Paragraph 4 of the state. Paragraph 4, no?
Here. Yeah.
It will. Same one, huh? Beleg. But he wants to appear. He wants the DYSGI. Yesterday, Mr. Arkadev Chaudhary, another funny thing happened in this court. Service was not, the matter came up for no steps. So no steps, I asked, why haven't you take steps? So the counsel says that, my lord, the order only says service being affected upon the Deputy Solicitor General of India, and as such, there was no mention who it is. Yes, who is appearing? Yes, what is the case?
Your Lordship, this order has been complied with.
Complied with. It has been submitted at the bar that the order dated.
Eight.
13/8/2025 passed in WPC number 2801/2025 have been duly complied with. Accordingly, the instant contempt proceeding stands dropped.
Much obliged. Hello.
What is this?
My lord, that matter pertaining to central destitute home where these petitioners were actually bringing before the concerned authorities for affording them with the benefits of the Pradhan Mantri Awas Yojana scheme. Now, affidavits have been filed both by the union as well as the state, where, my lord, both the
Mr. Rochori, yesterday, that day I could not take it up on account of taking into account the matter I asked your presence. Yes. What is it? What do you want now?
no, my lord, here my limited prayer at this stage is these petitioners submitted their applications before the concerned authority, more particularly before respondent number
In
six.
the judgment and order passed by so and so,
Now, these applications have been returned back by respondent number 6 on the
you
petition.
belong to some place. What was the place?
The central destitute home is where we have been placed.
I understand. Okay, now. I-
After having
They are there in the central destitute home. Now, the central destitute home is in a very pitiable state of affairs.
yes,
So they are therefore saying that instead of as you are not repairing it, kindly use the Pradhan Mantri Yojana, the funds from there to do it.
yes.
Okay, that is, but Mr. Chakravarti, the problem arises from this. The fund for doing it,
Yes.
from the Pradhan Mantri Yojana, there is a difficulty.
Right.
Taking into account that this is specifically against the particular scheme and particular manner of.
Yes.
Okay. But the fact also, this court cannot also give a blind eye to the fact that if the very name of the people, the home is for the destitutes, meaning thereby they are from the marginalized class of the society. So under such circumstances, Mr. Roy Chaudhary, put up your good office and do something for funding that, for doing some repairs. That is the only thing they work on.
And preliminary, before that, whether we are entitled under the scheme or not, that is to be assessed. Now that.
Why you are going into unnecessary things?
Oh, man. Well,
We are concerned that this needs to be.
well,
Pradhan Mantri Yojana is for giving certain amount of either money or houses to the people who are also of the marginalized class. Here we are having a destitute home of the central government. Yes.
Though it is named Central Destitute Home, it is being run by the state.
Social wealth, social wealth, social wealth.
So why you are not doing something? There cannot be nowadays of the record with, we are there in the internet, you are there everywhere, there cannot be an off the record.
It's on record.
Huh?
It's on record.
You are on record and it can be. You take it up on a particular manner in which it can be done. You are appearing for whom? You are appearing for whom?
Me.
You are appearing for whom?
I am appearing for the inmates of the central district.
How many inmates are there?
90, there are 99.
There are total 99
Yes.
inmates. So therefore, all 99 inmates are here.
Yes.
Now you can do it, but they have to vacate. Okay, but where will they go? Huh? Mr. Burwa, do you know why they are not staying with their family members? There's a reason behind. Maybe they are not getting the love and affection which they gave to their parents, the children they are not giving. That is why they are not staying there. Who would otherwise go and stay in a destitute home? Tell me. Give me a good idea. In India. I may consider outside India, it's a different aspect. They have very well organized old age homes or destitute homes, or all of these things are there. But in India, normally we have a culture by which you always take care of your parents. So sometimes it happens where the parents, the children, they don't take care. So they have no other option but to go there. They are not, these people are not criminals out there who have been thrown out from the house for doing all this thing. They are old age. What's settlement? No, there is no settlement. At this age, they are not going to ask for land. For whom?
There is a petition filed by 7 numbers of petitioners.
Out of the here 7.
No, these people, they had some connection with this central destitute home at some point of time. They segregated themselves. And now they have filed one writ petition which is presently pending before this honorable court, in which they have alleged that there is an endeavor being made by the authorities to settle some portion of the land of the central destitute home with concerned person. Now, we are
That's a
concerned.
different.
That's
They
a
are not
different
asking for that land.
No, ma'am.
Not that. My question is why the state is not providing this?
And
You have so much of money to do many things. Why not do that? How much, what will the cost of money?
and so far,
And maybe central, I think the central government also should step into this or ask or is the central government a party here?
yes, yes.
So therefore, let the central government also step in and do something good for these people. Something has to be done. Get the report from the social welfare director and find it out what is the cause. If he says that this is the question is that they are not vacating, you have to also find out what is the manner in which you have to. Just for example, tomorrow in your house, if repairs are being carried out, what are you going to do? They are, after all, they are there because they are destitutes. So therefore, they have to take care of them, then put him somewhere else for time being till you don't build it. Or make it somewhere else, make another destitute home. If it is a central state government project, you have to do it. Instead of, you see, the reason is, instead of, yes, I would say therefore, see the idea on which Mr. Chakraborty has built up his code. He said, then look here, a person who is of the marginalized class, the government of India is providing a yojana. That is the Pradhan Mantri Yojana. And thereby giving free homes or certain consideration for making certain amounts and grant needs. Apply similar principle out there and do something for this particular. Now tomorrow, if it is a case, I still remember that this Lokpriya Gopinath Bodle Mental Institute, it was in shambles at one point of time with prior to Sheila Barshe matter being taken up. And thereupon, on the basis of various directions being passed, and I think there was a monitoring. Now, is it there or not? It's closed?
Yeah, infrastructure is over.
Huh?
Infrastructure is over now, so must be.
No. There was a every time monitoring going on.
Yes,
It's
sir.
only the infrastructure, but otherwise also, as regards the condition. Now, I think because earlier I still remember the matter came up. Initially, it was given to Justice A.K. Patnaik. After Justice Patnaik was there, at that point of time, Justice Gogoi was the amicus appointed. After that, after Justice Gogoi was elevated, Justice Sumitra Sekar was the amicus. Thereafter, I don't know what happened. It is a matter of 1996. It was a continuing writ which was going on. A mandamus was looked into. But then also, it was looked into. And therefore, now you are having 100 people out there. You have to make either a facility by which you can make it bigger, because there is no, the people who are the destitutes is not coming down. It's only increasing. If you are having an area of 32 bighas, if it's an area of 32 bighas, I don't see a reason how, leaving aside one portion of it without touching that, you can very well construct a particular home with in 5 bighas of land out there, with a 5 or 6 story building out there. You can very well construct to put these 100 people or more than 100 or 200 people out there. You don't require such a 32 bighas of land. So the question that they cannot vacate, right, doesn't appear to be proper. So very good. That is there, but the fact that it is in a livable condition, that's the only issue. If it is not, it doesn't look nice.
It would be just like Lordship is taking up the matter today, the CJM court. So it would be just like that. You accommodate them in some place for some time till construction is over.
That is there, but you see, my question is that here a lot of expenses. But if the area of land is 32 bighas,
It won't be required.
we are only having 100. You can very well make another building anywhere. Demolish one part of it and make a building. This building of encompassing 100 people could not require more than 5 bighas. 5 bighas would be enough. 5 bighas is a huge area. This High Court is not 5 bighas, this present pro. So therefore, you have to understand that The other, the High Court is also, the other old building also is just above 5 acres. That's all. Yeah. You can make a building like that nearby, next one, which is only 10 acres. Next one. If you can make such a colossal building there, why not in 32 acres you can make? Isn't it? Okay. I'll pass the order too. Yes, that is what I propose to pass. Ask the area why it won't be given. And I'll also ask the central government as to why maybe it is a state institute, but taking into account that these people are marginalized class, why the central government cannot also provide the necessary aid to the government of Assam for doing the need. Let us ask them. Which department will be better for the
It will be housing and urban,
central government?
Ministry of Housing.
I think we'll pass that one. The learned counsel appearing on behalf of the petitioner, Mr. R.K.D. Chaudhary, the Deputy Solicitor General of India,
Or one,
assisted by Mr. A.K. Doctor, who appears on behalf of the Union of India, and Mr. S.R. Bulwer, who appears on behalf of the Social Welfare Department of the Government of Assam. The petitioners herein who are 99 in number admittedly belong to the marginalized class of the society, residing as inmates in the Central Destitute Home, Meherpur, Silchar. The said Destitute Home was earlier established on a plot of land which was 57 bighas. However, on account of parts of the land being allotted to various institutes and organizations by the government of Assam, at present, the Destitute Home is situated over a plot of land at measuring 32 bighas, 3 katha, 12 chataks. The grievance of the petitioners herein is the state of affairs of is the pitiable state of affairs of the condition of the destitute home. As there has been no repairs being carried out. It is under such circumstances the petitioners have joined together and filed the incident with petition so that at least the scheme at least the benefits provided in the Pradhan Mantri Awas Yojana Urban be provided so that the destitute home could be renovated and repaired thereby making it conducive for the inmates to reside there. In a better living condition. Having basic amenities, which is a facet of Article 21 of the Constitution. Taking into account the scope of the present petition, which touches on rights, on the fundamental rights, which touches on right to life of the petitioners to live a life with basic dignity. This clause implores upon both the central government and the state government more particularly the Ministry of Urban Affairs, Housing and Urban Affairs, yes, Government of India, and the Ministry, the Department of Social Welfare to place a proposal before this court as to how the living conditions of the people, of the inmates who are the petitioners herein, can be improved by carrying out renovation and repairs. List this matter again on, let's have it on 3rd of, have it later on 10th of August.
That's fine, Harsh.
On 10th of, on 11th of August 2026. In the meanwhile, the ministry, the central government as well as the state government in their respective departments, more particularly referred to herein above, shall consult with each other in the aforesaid respect and place a proposal on the next date. List the matters showing it to be partnered. We put it as partnered.
Deeply.
What is this?
My lord, in terms of lordship's last order, today morning we filed the affidavit. My lord.
At least Mr. Ayabotako today has not stated that I need an adjournment.
Sometime may be allowed, my lord. Let the affidavit come, my lord, on record.
An affidavit has been filed by the PCCF, huh?
This is it.
By the PCCF as directed by this court by the order dated 30/3/2026. However, the same is not on record. Accordingly, list this matter again on 16th of June 2026. In the meantime, petitioner granted liberty to file any reply, rejoinder thereto. I don't think you need to file a rejoinder.
My lord, they said they'll be filing two affidavits, so in one.
No more. One affidavit, I've only asked the PCCF to file that. As regards whether, what is the
Well, they have
boundaries and
admitted,
whether
it's
these
in the
are
buffer zone now.
That's all. We don't require any more affidavits.
Well,
And
in
if
the,
those affidavits are there, so and so, your basic case now is what? Then look here, forget about 9 and all. We can't do anything in view of these two, the Wildlife Protection Act as well as the, what we call the other one, the environmental that, there's the forest conservation. Because of those two, we cannot give it because it's a tiger reserve and all this thing. It is in the core area. You have mentioned it as a core area. If it is a core area, you can't give it to them. I understand. You can't give it to anybody also. I understand.
Normally, they are saying it's a buffer area. They have stated it's a buffer area.
Who says?
They stated in their affidavit. my lord.
Now they say it to be buffer.
Buffer.
buffer, but my lord.
Then
that
you ask Mr. D. Gogoi to appear because he keeps on misleading this court by making all these submissions. Next. You interchange your counsels, huh? Come up. Now, when you say buffer, then your all these things will not lie.
All right.
My lord, in this matter, my lord, pertains to settlement of a certain work, my lord, for repair and renovation, my lord, in the district of Lakhimpur. My lord, in this regard, once the tender committee has finalized and accordingly notified for allotment of package number 2 and 6 in favor of the petitioner, but my lord, subsequently, without knowledge of the petitioner, my lord, the
That I
authority.
know.
Yes, my lord.
You also say that you are going to do as per 2023 rates. Without
Yes.
asking for any escalation. Therefore, we are now proceeding.
Yes.
Yes. They filed your why you have given it? The verification report.
There, my lord, I have sought for.
I have to ask you to file an affidavit. You don't have it.
Affidavit we have filed. They now furnished the.
Okay, you have produced the verification report.
That report, my lord, yes, it's not there in the plans, my lord. They have furnished to me.
Huh?
Well, I did not find that report.
Prayer for extension of timeline for a year. You don't have the verification report.
It's not there in the plan, my lord. I repeated.
So therefore, we set aside that.
Leave it to your lordship, my lord. Is that
You
repeatedly-
go ahead and do a fresh one.
My lord, otherwise also, my lord, that subsequent review has been made without giving opportunity to hear, whereby national principle of national justice has been violated,
Tender,
my lord.
there is no question of national justice.
Why not, my lord? My lord, once they have finalized, my lord, then subsequently, on what basis that have to be, I have to know, my lord, but they have not provided anything, my lord. My lord, kindly
I
see the
can,
affidavit.
Mr. Saikia, I can at best set aside that. as
Yes, my
regards 2 and 3, 2 and 6.
Yes, your lord.
I cannot go beyond that. I
That is
can't
correct,
ask
my
them
lord.
to give it. They
That-
may very well come up with another decision.
That is correct, my lord.
And they may give the decision in another 4 years' time. Then you would be bound to do it. You like to do that.
After 4 weeks, how it will be possible, my lord, because escalation is there.
So therefore, I can very well only set aside that, asking them to go for a fresh one then.
Well,
For those two items. For those two packages.
Because the stay was only for package 2 and 6. Because there is no verification report.
Lordship.
Yes,
So the entire basis of the affidavit, the stand on which they have exercised
Lordship.
in respect to changing it by the impugned order is required to be interfered with.
yes, my lord. Otherwise, also, my lord, in the subsequent meeting, my lord, my notes has been annexed with a affidavit, my lord, where about verification report, nothing has been mentioned, my lord.
Therefore, when they lose the basis,
Yes, my lord.
I will interfere with them, leaving them, because now allowing them to give it to you later on means they may take a stand, okay, give you after 2-3 years. Then
Correct,
what will
madam.
happen?
Correct.
And I can't give you that you go ahead. Heard Mr. M. Saike, the learned counsel appearing on behalf of the petitioner, and Mr. B. Gogoi, the learned additional advocate general, as well as standing counsel for NHM, appearing on behalf of the respondents. The petitioner herein has assailed the notice dated 11/12/2023, whereby the respondent number 7 and 8 have been allotted package number 2 and package number 6 respectively, which was earlier offered to the petitioner by notice dated 21/9/2023. The learned counsel appearing on behalf of the petitioner submitted that the said actions to do so was without any reason and just to deprive the petitioner which was deprived the petitioner. And as such, the impugned actions being unreasonable and arbitrary is required to be interfered with. This court duly takes note of the affidavit in opposition which was filed by the respondent number 2 and 4, wherein the stand so taken is that pursuant to the offer which was made by notice dated 21/9/2023, the District Commissioner, Lakhimpur, requested the Joint Director of Health Service, Lakhimpur, to conduct a verification through the Finance and Accounts Officer of the overall tendering process. It was on the basis of the verification conducted by the Finance and Accounts Officer, the decision was taken to allot the work in respect to the package number 2 and 6 to the respondent number 7 and 8 by the impugned notice dated 11/12/2023. First, this court also takes note of that in the said affidavit in opposition, the verification report have not been enclosed, which form the basis of the impugned notice dated 11/12/2023. It is under such circumstances, the matter was heard at length on 13/5/2026, when this court directed the NHM to produce the verification report. First, it is also very pertinent to take note of that on 13/5/2026, this court fixed the matter today on 21/5/2026 at the instance of the Standing Counsel of the NHM. First, today, it has been informed to this court that the said verification report is not traceable. Taking into account that the very basis on which the impugned notice dated 11/12/2023 is not traceable and cannot be produced before this court has to presume that the said impugned notice dated 11/12/2023, the very basis of the impugned notice dated 11/12/2023, insofar as the package number 2 and 6 being awarded the respondent number 7 and 8 is illegal, arbitrary, unreasonable, and suffers from malice in law. According, this court therefore disposes of the instant writ petition with the following observations and directions. The impugned notice dated 11/12/2023, insofar as the package number 2 and 6, which was awarded which was offered to the respondent number 7 and 8, is interfered with. The respondent authorities shall be at liberty to proceed afresh in respect to the package number 2 and 6 by issuance of a fresh notice inviting tender if so advised. Number 3. This court, however, clarifies that the interference to the impugned notice dated 11/12/2023 is only limited to package number 2 and 6 and not in respect to the other packages. With the above, the petition stands disposed, no cost.
NSM and health, it has been issued by the Joint Director Health Services. What's the syndicate?
Joint Director Health Service. NHN and health.
After some time, P9 is late to court number 1, his first half. He will be here.
Oh, this one. It's okay. No problem. Because the P9 not be there. Now, this is a case, Mr. Gugoi, it's of serious consequences.
Yes, initially,
Have you seen the order which I have passed?
no, that I was.
I tell you what. A contract was awarded to Mr. Das's client. On account of contract being not completed, contract was terminated. This termination was put to challenge before this court. At that time, they also was challenged before this court. When it was challenged before this court sought for a report because they were, in the meantime, also given it to him, the contract, without tender, given it to him. When the matter was being taken up by this court, not me, another court, a report was sought for as to how much work was there and how much work was not there, how much work remained. In a report which was submitted on 6/8/2024, if I'm not wrong, 24/22, it was categorically mentioned that the work was completed, the work which was awarded to him was completed in all aspects. And what remained out there was only to make him the payment which was not made in view of the directions passed by this pendency of that petition.
Right.
The learned court bench, in taking into account the above, did not interfere with the termination of him and say that there appears to be something, there was some problem out there, taking into account certain money was released to him.
Yes.
By the executive engineer even before, without completion and all. And he was also granted the contract without a tender, risk and cost tender, no tender, but it has been done. So an inquiry be conducted internal amongst the PWD officials. Till there, okay, you can think that okay, things are okay, not so bad. Thereupon what happens, the chief engineer again revisits the decision and cancels the termination which was made to him and grants him again a contract of now 51% of the remaining work. 51%, meaning either the affidavit which have been filed before the court is wrong, that the contract was over, and this was not done by anybody else but an officer not less than the rank of an additional chief engineer who has submitted. Now the question is, because of that, and held that the termination which was made, which the court did not interfere, termination which was made by him, as regards him, that no notice and all these things, these are actually what he said is right. And as such, now the same work is now being given to him to do 51%. In the meantime, 1 crore 94 have already been paid to him. And a new contract of 5.71 crores is being given to him. It is under such circumstances the math is this. True facts. So we were thinking, Mr. Naik was saying that one should go for a CID inquiry. Because the inquiry which was given by this court in the earlier occasion had come up with a report which appears to be completely contrary to what stand the chief engineer now takes.
Well, conflicting views.
No. My question is not on that. Whether it is given to you, I'm not bothered to that effect. I'm not on bothered to that. We are more concerned with the public money. We are more concerned with the additional chief engineer submitting a report before this court. Mr. Gukoi, kindly see the order passed by the learned coordinate bench, the judgment dated 3/11/2022, which is a part of the petition at page 34.
Para 51.
No, let us not go to para 51 before. Kindly see this para. Page 51. Para 16 on top. Page 51 on top. He has quoted the report.
16.
Got it? The entire work of PMG swap package number AS 13278. Page 51.
Yes, ma'am.
On top.
Yes, ma'am.
The entire work of PMGCI package number AS 13278 has been completed on 26/5/2021, and the running bill for the balance amount of rupees 191,18,264 was prepared and has been paid with necessary deduction to contractor so and so, that is him. till date. Though the work has been completed on 26/5/2021, final bill has not been prepared and payment could not be made as the Honorable Gauhati High Court had allowed payment of 50% of the balance work value till disposal of the matter. Completion details are available in the OMMS site. So the work has been completed. If the work has been completed, how on earth the same work is being given to him? And this is you see the report. Kindly see page 49, paragraph 49. The inquiry report prepared by the additional chief engineer PWD makes certain startling revelations, more particularly with the manner of allotting the balance part of the work after the order of termination. In particular, the observations made in paragraph number so and so are of grave importance, which are extracted herein below. It is, however, not to be understood that the rest of the observations are not less important and are to be acted upon as follow-up action. Now here, this is has happened. It is very interesting. Kindly see page 50. Measurement was done of the work carried out by him on 22/2/2021. Okay?
Yes.
Last measurement recorded.
Yes.
Then contract LOI was, however, issued on 8/2/2021 in his favor.
Prior to that.
My question is, if the work had been completed, how can that tender be issued, contract be granted to him? And what was the leave granted? Kindly see page 51. I think we are concerned. This is a case where something is wrong.
Yes.
Seriously.
Between the two authorities, district and the
Huh? I think
district authority and the office of the civil.
we therefore direct. We are not going to interfere with anything else, but we direct the CID to conduct an investigation. CID will be better or CBI? CBI. Where? Still pending because there is some stay order is given, na? Huh? Huh? What vitiates everything? Mr. Das, we are not concerned on much on that. Whether that was done or not. But on a false affidavit being filed before this court, it's a very serious thing. So I have asked this PWD authorities are put to notice that in the several discrepancies are noticed in the report submitted before this court in so and so. This court would initiate appropriate proceedings against erring officials. So not on pension, I'm not on that. You see, what the executive engineer has done, I'm not concerned. State has a lot of money, they can give it to many people. I'm not on that. My main concern is when an court had asked for a report to be given by the chief engineer, an additional chief engineer gives a report which is false. Either false, the chief engineer, the present chief engineer apparently contradicts it by going ahead and saying that the termination which was made against you was wrong. How much work? Then why have you been given 51%? How much work have been given? And how much was the initial contract?
To me, appear correct. And now we go work.
Huh? So you, though you have quoted 6 crores something, and the contract was granted to you at 6 crores. But you say now that as you have already received 3 crores earlier, you are going to do the entire work at 5.717.
Now the payments will be on 1 crore and 6, which is available with the office. Versus the rules. And on recovery of the remaining amount.
But the new tender says 5.17. Yes. I think the person who has done anything, it's a case of, I don't know others, it's a case of 409. Don't you think that criminal breach of trust? This is not a case for the purpose of, inquiry again. No, inquiry is okay. Departmental inquiry is different. This is a case of 409. Criminal breach of contract, trust. falsification of a document 394 before this court. But as the activities or as the actions were taken or the false evidence having been placed before the court was before Justice Medhi. Could I endorse this matter to him better off, but to the Justice Medhi, taking into account that the initial order was because it was before him the fraud was committed apparently. Yes. The first order passed by in this. He had passed the judgment. Right. After the judgment, Mr. Das, after the judgment passed by this court, holding that this court is not going to interfere with the termination order, the chief engineer says that, okay, whatever the High Court may say, it's okay, we are not bothered to the effect. But I hold the termination to be bad. It's such permissible. Mr. Bukoi, you have been dealing with the PWD for a long time. I've never seen a chief engineer saying. No, they relied upon to the order passed in the division bench order. That while the matter was pending for the division bench, in the bill number 397 of 2022, it was informed that this order has been issued. So you will see page 116 of WPC, the data bill which was withdrawn by the. Yes. Which case? 837, huh? 837, page 106. 106. Yes, sir.
Which was withdrawn by the appellant, my lord.
106 is where?
In the new one, my lord, 2026 case. WPC 837.
106 is different. Who has enclosed this?
837, my lord. Yes, Gulzar Hussain Chaudhary.
837.
Page 106. No, 116. Sorry, sir. 116. 116.
This is another one. What is this matter?
My lord, they preferred writ appeal against the single bench order, and the writ appeal was withdrawn, my lord, subsequently. Also, you will see page 119, my lord.
Last second para.
This is against in 4887.
No, my lord.
First order.
Petition 2243 of 2021.
So there's no finding.
No.
How does this have any relevance? This order is as if the learned senior counsel seeks for an withdrawal and details have been given and then said learned senior counsel seeks for an withdrawal. Hardly makes a difference. This type of orders cannot help you.
Now, Lordship will see page 121.
And that too, this order was passed at a stage when the earlier, prior to that, the withdrawal happened by the chief engineer. That No. Therefore, this order which was passed on 7/8/2023, 25 was preceded by an order holding that your termination was illegal. The termination was illegal by the chief engineer. So therefore, how could the chief engineer exercise that? My
In view
question
of
is
the-
this.
In view of the learned single judge's order.
After the single judge's order,
Lordship will see page 121.
okay, we do one thing. How much money you have to pay? 23 lakhs.
No, 1 crore 70 something, my lord.
Okay.
One,
We remove the big deal. Take action against him. Take the money from him. Let it be, don't spend it, put it out there. You can't have that illegally. We have not done any work.
no, we have.
We have not done any work.
No, it was
Report,
already
you
complete.
see that additional chief engineer saying out there, you cannot retain the work. Then in that regard, you have given have you given that if you lose, you are going to indemnify? No. You
My
say
lord.
that you give the stay will be subject to you saying that, okay, in the circumstance you lose the case, then the state would be entitled of the amount along with interest at the rate of 8%,
My lord,
and which you are likely to lose.
my
Let
lord,
the state get the money. What do you say?
my lord, kindly consider one thing, my lord.
Yeah,
The amount of work that I have completed, my lord, that's
Mr. Gugoi, you do one thing. First, you give me the names of those three of us. One is the chief engineer, present. The second is the additional chief engineer who submitted the report before the score. And the third is the executive engineer. He may have done all these things, but I am going to ask them to initiate. I have to make them a party and then initiate proceedings against Huh? Where? Where? JK Ustam, is he working? It's okay. So we have to make him a party. Mr. J.K. Goswami, the chief engineer, you have it, and the other executive engineer was Nurul Islam. Nurul Islam, we have it. We have his name. So
And my
we
lord,
make him a party by this court. Make these three people a party, and then we say that why we ask the DGP to make an inquiry on a criminal, and if necessary finds out anything out there, then to initiate criminal proceedings, make an inquiry, and then to have a.
and my lord, the inquiry which was conducted prior
No,
to
this
the.
type of inquiry would not do.
No, no,
This
my lord.
inquiry was
No,
been
no, no.
called-
I want to submit another thing, my lord. The inquiry which was conducted pursuant to the judgment passed by this honorable single judge, my lord. That inquiry report shows that, my lord, they have only inquired, they have made only the office inquiry regarding the termination of the contract or allotment to the petitioner. But they have not made any finding, or they have not made any field verification to find out, my lord, actually completion of the work, my lord.
So therefore, I'm not saying that it has to be only you to be at fault.
Yes, my
Mr.
lord.
Das' client also may be at fault.
Yes, my lord.
So therefore, let the police investigate
Yes,
that.
my lord. Let them in, but the
Let the DGP
physical
make an
verification will.
investigation and submit a report, a preliminary report before this court in the month of July, third week. Huh? A preliminary report be given.
Yes.
Regarding, how do I know that it is fraud? Your person, the chief engineer maybe have committed fraud.
Yes.
Chief engineer may have committed fraud. It may have been made by the additional chief engineer who had committed fraud. Or the executive engineer may have committed fraud. Your client may have committed fraud. His client may have committed fraud. Only two persons I can say they have not committed fraud is Mr. B. Gogoi and Mr. P. Nayak. Rest everybody may. But on the other hand, the work has been stalled. You have not been able to do the work. Now, how to take care of that, Mr. B. Gogoi?
Work is complete as per the report. That's why the
there are two
verification is
conflicting
necessary,
claims,
my
my
lord.
There are two conflicting claims. He
Yes.
says, my lord, balance work was allotted to him, he has completed it.
Balance or.
And
Now,
that is
my
on
lord, they
affidavit.
receive again, my lord, to the
Ah.
first contractor.
That's why, my
Challenging
lord.
that he has approached, that, my lord, how can he be now allotted the work where I have already completed it? So
That's
my
why-
money will go, that's his claim.
Field
So again, my lord,
verification is
that will have to be
necessary.
inquired into now, my lord. And my lord, Lordship will give a, my lord, third party to have a look at that part, because same authority, if they inquire, again conflicting reports will come, my lord.
Hmm?
Yes. Independent authority, my lord. Any authority, my lord, to see whether, my lord, actually work has been completed, and if completed, my lord, who has completed?
Yes, my lord. That I also
Either
agree, my
party,
lord.
my lord, claim. On,
Let
my
the
lord,
third party-
regarding payment and all.
Fraud will be decided.
Let
the
them
report will
inquire,
come
my
from
lord.
the CI. So which person should I give? Or lordship may direct the present chief engineer to have a court a government. No, he's then the main problem. Then government commissioner secretary will be on the room. They will take a call on this. Field report, my lord, not on my lord. What
Yes,
is there
my
in the
lord, field report, my
Actual
lord.
field
Even
report.
I want that, my lord. Field verification must be made, my lord. Who has completed or what amount of work has been completed, my lord, and who has completed?
This inquiry was conducted personal findings of a making of special commitments with that is page number 217.
And that inquiry report doesn't reveal anything regarding the execution of the work.
Order lordship may direct the deputy commissioner to my lord present.
No, he's too late. You have to see the protocol.
My
Deputy commissioner would not have the ear to make it. You have to be a senior and something. You're concerned with the chief engineer. Chief
in that case,
engineer
my
is
lord, the
very-
commissioner and special secretary, my lord.
Huh?
Commissioner and special secretary, my lord, PWD notes.
I think that is the better option.
Respondent one in all these cases. The address is different thing, my lord. Who will tell the report?
Address would not. I'm asking him to put it. So let me quote the order of 4-5 and ask him to submit a report.
Yes. In the meantime, we'll provide the names and all manner of the.
Heard Mr. D.P. Bora, the learned counsel, appearing on behalf of the petitioner in both the petitions. Mr. B. Gogoi, the learned additional advocate general, as well as the standing counsel of the PWD. And Mr. DJ Das, who appears on behalf of the private respondent. Next. All does not seem to be well in the PWD department of the government of Assam. And this aspect would be apparent from the facts involved in the present proceedings. In the order dated 4/5/2026, this court have duly noted down the facts and have also expressed serious doubts on the acts of certain officials of the PWD. The acts which are subject matter of the present proceedings would show that there is a discordant note as regards the work being completed or not amongst the very officials of the PWD. The acts which are the subject matter of the present petition. If true, not only amounts to floundering of the public exchequer, but would also show fraud being played upon this court. The order dated 4/5/2026 passed by this court would clearly show, the order dated paragraphs number 1 to 13 of the order dated 4/5/2026 being relevant is reproduced hereunder. Are reproduced here. Indeed, this court have perused the records. The record to exit, 72243. Isn't it? Perused the records of WBC number 2243/2021. In pursuance to the order dated 4/5/2026. And it is the opinion of this court that there is a requirement for initiating certain proceedings against the erring officials. However, before doing so, this court would like to seek a report from the highest authority of the PWD, that is the Commissioner and Special Secretary to the Government of Assam, PWD Department, PWD. As regards the as to who are the officials who not only have as to who are the officials who should be directed against whom proceedings should be initiated by this court in view of the dispute involved herein. Mr. B. Gogoi, accordingly, this court fixes this matter on 4th of August 2026. In the meantime, the Commissioner and Special Secretary to the Government of Assam, PWD, is directed to carry out an inquiry by calling the officers who have been involved causing an inquiry and submit a report by way of an affidavit on or before 30th of July 2026. Huh? You want to go do work, but you can't take money. No, you want to do work, do work. No, you want to do work, but no money. Okay. No, it's okay. You do work, no money. Because tomorrow, if we come up and find out that the work is completed, so you want the vacating of the interim?
So my lord, inquiry report should indicate regarding the execution of the field verification also.
I've put everything.
Yes.
I think, Mr. B. Gogoi, you kindly explain it to your commission.
It will be PWD roads. PWD roads.
PWD roads.
Because earlier round of inquiry, they did not make it.
No,
Yes, sir. Problem. Lordship, we have some instruction on this. Yes. Lordship, senior is on the way. He's coming.
Give the instruction. Yes, what is it? You have the budget?
Well, yesterday, yes, Baba, I have received the instructions. The budget has been given by the department. Now the DC will take the steps now. Now the DC will take the steps for release of the amount. The department has given the budget yesterday.
So the money has come to the DC.
Yes, but budget has been given.
So let's have it again on 8th of June.
But can it be after 15th? Can it be after 15th of June? It may take some time.
Have it on 17th of June
7th.
for providing the update.
Lots.
And in the meantime, you disperse.
Mal. I'll suggest them to do that.
Pursuant to the order passed by this court on 25/2026, Mr. Dinath, the learned senior government advocate, has placed before this court an instruction issued by the District Commissioner Morigaon, which is kept on record and marked with the letter X. From a perusal of the said instructions, it is apparent that the budget allotment of an amount of rupees 6,21,800 have been received by the District Commissioner Morigaon, and necessary proposal for financial sanction, etc., is under process. It has been informed to this court that the said amount would be released on or before 15th of June 2026.
They will try to do it.
If you don't do it, then we do one thing.
Lordship may not record that they
No,
will,
we
they
will do
will
one thing.
definitely they will take.
We then fix it on 1st of June.
No.
1st of June, there is another good one. Another good bench is coming for this matter.
No, kindly.
So then it will be better. He's going to, because then the salary month comes.
Lordship may keep it on 17th, but I'll tell them to do it immediately. Let it on 17th.
Would be financial sanction and necessary proposal for financial sanction, etc., is under process.
I'll place the update.
It has been, this court has been given to understand that the amount is likely to be released in a short span of time. List this matter on 17th of June 2026. It is observed that this court observes that in the meantime, if the amount is not released, this court would be compelled, would be constrained to pass appropriate orders.
personal trade license from the name of deceased husband of the petitioner to her name. But the land
I say that I will pass the order subject to you getting me the judgment of Justice Manish Sinha. May I have copies? We allow this. We make it an exceptional circumstances and allow you issue the license without insisting on the no objection. The petitioner, who is a widow, running her livelihood, carrying on a livelihood, by having a shop for retail sales of spectacles and other optical equipments, have approached this court seeking a direction upon the Bongaigaon Municipal Board that the trade license be issued in her favor. The brief facts which led to the filing of the present petition are that the petitioner's husband one Hare Krishna Das, since deceased, was a tenant of one Sri Hemendas, wherein late Hare Krishna Das had set up a shop for retail sales of spectacles and other optical equipments under the name and style of Nisa Optics. The husband of the petitioner obtained a trade license from the Bongaigaon Municipal Board, municipality as it then existed, now Bongaigaon Municipal Board, on yearly basis. When did he die? Unfortunately, the husband of the petitioner expired on 30/8/2023. The petitioner in order to earn her livelihood is presently running the said shop. However, on account of landlord-tenant dispute between the petitioner and Sri Hemendas, who is the landlord, and there being a civil suit pending, being title suit number 131/2023 before the Court of the Learned Civil Judge Senior Division, Bongaigaon. No objection certificate have not been issued by the landlord, and resultantly, the Bongaigaon Municipal Board is not inclined to issue the trade license in the name of the petitioner. Though the Bongaigaon Municipal Board have renewed the trade license in the name of the petitioner's husband, who had expired in the year 2023. It is under such circumstances the present petition has been filed. Ms. So-and-so, the learned counsel who appears on behalf of the petitioner, submits that like electricity, which is an essential service, without a trade license, the petitioner cannot pursue with her business, as it is the requirement that for carrying on any business, there has to be a trade license. She therefore submits that as the petitioner is a tenant and the eviction proceedings so initiated by the landlord have not yet been decided against her, and the law being settled that there cannot be that a statutory tenant cannot be evicted without due process. The non-renewal of the license on account of the no objection not being submitted renders the action on the part of the respondent authorities arbitrary and unreasonable. And more particularly, when the petitioner's right to life is in question. In that regard, the learned counsel referred to the judgment of the Supreme Court in the case of Dilip Dead versus so-and-so, reported in so-and-so, as well as the judgment of the coordinate bench of this court in the case of Mohit Kumar Dev Roy versus Gorangalal Roy, reported in 1986 1 GLR 442. Mr. S. Biswas, the learned counsel who appears on behalf of the Bongaigaon Municipal Board, submits that the trade license is granted to a tenant subject to the no objection granted by the landlord, inasmuch as and that being the mandate followed, in it, that being the mandate followed by the Bongaigaon Municipal Board in respect of all persons, comma, the said action cannot be said to be unreasonable or arbitrary. This court had given an anxious consideration to the respective submissions and have also perused the judgments which have been laid emphasis upon by the learned counsel appearing on behalf of the petitioner. A trade license is issued by the municipal board for the purpose of collecting fees on account of the constitution. The constitution. Profession, trades, callings, and employment. Which comes within the ambit of entry 60 and entry 66 of list 2 of the 7th schedule to the Constitution. The said trade license being a tax or a fee collected as a revenue for the municipal board and not for the purpose of regulation of the tenancy, the insistence upon the no objection certificate from the landlord in the case of a dispute between the landlord and the tenant renders the action on the part of the Bongaigaon Municipal Board arbitrary and unreasonable. This court also takes note of that without the trade license, the petitioner cannot carry out any business, as it is the mandate that there has to be a trade license. In addition to that, under such circumstances, non-granting of a trade license to the petitioner amounts to taking away the right of life of the petitioner to live the life affects the petitioner's right to live with dignity on the basis of a livelihood. In addition to that, it is also pertinent to observe that when there is a dispute which is pending before the civil courts pertaining to eviction, it is not expected that the landlord would grant the no objection certificate. And if such a course of action of insistence for a no objection certificate from the landlord is allowed, is allowed to be perpetuated for grant of a trade license, it would amount to eviction of the petitioner for reasons other than the reasons mentioned, other than the grounds mentioned in the Assam Urban Area Rent Control Act 1972. Consequently, this court therefore disposes of the instant writ petition with the following observations and directions. Number one, the writ petition, the Bongaigaon Municipal Board is directed to forthwith issue a trade license in favor of the petitioner, subject to the petitioner complying with the other mandates required by the Bongaigaon Municipal Board, and without, however, without insisting upon the no objection certificate from the landlord. The said exercise be carried out within a period of 15 days from the date a certified copy of the present order is served upon the executive officer of the Bongaigaon Municipal Board. Number three, this court further observes that the above judgment in any manner would not affect or prejudice any of the parties in title suit number so and so, which is presently pending before the court of the so and so. Yes. And this was. Disposed of now. 76 have been disposed of. Yes, on the last. Mr. Dekar, 76 have been disposed of. What remains? One is WPC number so and so, and the other is
2362 has been.
2362. That has been revived. Now,
We can take that IM.
you have filed reply.
I have to file a reply here. We'll have to file a reply
Why haven't you filed the reply?
because they've been revived only on the other new creation council. This one was not revived.
Even you more than, not much, 15 days I've given, na? 21 days, 22 days. How much time do you require?
2 weeks?
6 months?
2 weeks?
Okay. I'm having this matter again on 9th. In the meantime, you file it. What is your objection?
There are lots of objections.
I'm only opening up the CRP. I'm not opening up, disposing of the CRP. CRP remains. only opening up the CRP to the effect that this order by which it has been disposed of is. What is your objection? I'm not disposing of the CRP. CRP is against an order passed. In some proceedings, some injunction not being granted, as some order has been passed or injunction granted, some order has been passed against it. Now, what has happened? The learned coordinate bench of this court had passed an order appointing somebody as a commissioner and to hold the election.
Right.
What election was held till then, it is okay. I'm not on that. But the court ought to have this, kept the matter pending. That's it.
Yes, what would have kept the matter pending?
That is the only option.
Because the report was submitted by the person concerned.
So then I could have considered the report of Mr. Doctor, who was the commissioner, and thereupon to pass appropriate orders.
That was not very.
So therefore, this matter, if I'm allowing it, will only bring the CRP into a life. So that that order can be passed, whatever necessary orders, whatever may be, that can be passed.
Only
But why are you having an objection against this? You may have an objection against the CRP order.
Yes.
But I don't
that we
think
have.
this requires, because
If it's only limited to keeping the CRP
alive. So I'm bringing the CRP alive.
That can be done.
So that is what I'm saying.
That can be done.
Once without the CRP being alive, because I'm not going to pass the order on CRP, what is to be done? That will be taken on the basis of the report which has been submitted by Mr. S. Datta. And as to whether it is permissible, proper or not. So there the things will move.
To that extent, it's so. That we have no objection.
So then I can allow this IA only to reopen it.
Keep that CRP alive.
Not only, and recall it to that effect that the order insofar as closing the CRP during the pendency without the report being submitted was a mistake committed by court. And therefore we open it up and thereupon we'll see what happens.
Yes,
what do you say?
So basically, Manoj, if I've understood it correctly, 27/8/2019, that consent order remains, Manoj. The exercise will be done, but it will not amount to disposal of the CRP.
Only
That
the
is-
CRP.
And once the report comes, then consequential orders
Now,
can be.
now the report, then I can look into it. Once the report is look into it, and if the commissioner says that under no circumstances can be held for whatever may be reason, then this court will have to pass further orders,
Right,
whether there is
right.
a consent or not, or whether the revision at all could be maintainable or not. So whoever has filed a revision, you have filed or you have filed, whoever has filed that revision,
We have no
that
objection.
has to look into.
Then,
So therefore, that is there. So I don't think filing an objection out here makes any sense.
then we shall not file.
Okay. Heard Mr. P.D. Dekar, the learned counsel, appearing on behalf of the applicant. Mrs. M. Azorika. Here, this applicant is also in a different shape. Fine. In the application.
2362.
2362, I'll be here for respondent report.
Mr. Where is the application? Huh? Oh, yeah, got it. Heard Mr. So-and-so appearing on behalf of the applicant. This is M. Hazarika, assisted Senior counsel assisted by Mr. A. Biswas appears on behalf of the respondent number 4. Mr. M. K. Chaudhary, the learned senior counsel assisted by Mr. M. Sharma appears for the respondent number 5. Who appears for 2 and 3? Last time I asked you to get hold of somebody. 2, 3, 4. All,
4 we appear.
2, 3. 2 and 3. 1, 2 and 3. You appear. I don't know who is T. Daily. You appear for 1, 2 and 3. Mr. So-and-so appears for 1, 2 and 3. This is an application for recall of the order dated 20 of the judgment dated 27/8/2019 passed in CRP IO number 244/2019 on the ground that a mistake had occurred in passing the said judgment by disposing of the revision application and without awaiting the report of the commissioner. It is also mentioned at the bar that on account of the said mistake, the election which was directed to be held by the order dated 27/8, by the judgment dated 20, it is also mentioned at the bar that by the judgment dated 27/8/2019, there was a direction to hold the elections of the respondent number 5 on election, under the aegis of Mr. S. Dotto, who was appointed by the commissioner. However, the election could not be held and a report was submitted by Mr. S. Dotto, the commissioner. And on account of the closing of the revision application, the said report of Mr. S. Dotto, the learned commissioner, could not be taken into account. This have resulted in causing prejudice to the parties to the instant proceedings. It is a settled principle of law that when an order is being passed by the court, which results in a mistake, thereby prejudicing the parties, it is an incumbent duty upon the court to recall such order so that the lease between the parties could be settled. Recall the state order. Accordingly, taking into account the above, this court therefore recalls the order dated judgment dated 27/8/2019 only to the extent of disposing of the revision petition being CRP IO 2449/2019 and restores the revision application being so and so to the file of this court. This court clarifies that by this present order, this court have not touched, have not decided, have not recalled the directions so passed at paragraph number 5 and 6, paragraph 4, 5, and 6 of the judgment dated 27/8/2019. Which shall be subject to further decision of this court after taking into account the report which have been submitted by Mr. S. Dr., the learned commissioner. I stands disposed. Now comes review petition. You want to file it? No, not main petition. Where is the main petition? CRP. You want to file a reply? What is the order seen?
Order was, they had filed an application in the main title suit, saying that the matter had become infructuous. And that was rejected by the trial court, against which they had come before.
What? Where is the order?
Page 83.
90?
84.
Huh?
Counsel.
In the revision, what have you
90,
challenged?
90.
90. Who has filed?
They have,
You have filed the suit.
I
They-
had filed the suit.
They had filed the suit, my lord.
I had filed the suit, and
No, this is for praying
point
for
of time,
amending the
committee
plain.
had filed the,
Amending the plain by making certain additions. The objective.
There were two
The relief
petitions.
sought by the plaintiff in the suit is primarily for violation of the rules and regulations of so and so. Furthermore, the discretionary under has to in own limits in the same cannot be used to dismiss a suit because for dismissal of the suit, proper reason is required both in so and so.
Basically,
Petition is filed by EA for dismissal of the suit. You have come before for dismissal of the suit.
not me. What had happened was they filed the suit challenging an election of 2015-17. Then the defendants filed an application that the tenure of that election and the committee is already over, so the suit has become infructuous. So in that CRP, the consent order was passed, which your lordship has said.
Which was never the subject matter of the suit.
Actually,
No.
actually.
Now, in the meantime, your suit has been here.
it has
We
been-
do one thing. Now we have recalled this order. Now you do one thing. You file an application before the trial court for reviving the suit.
I have filed a review.
Now, understood. Now take this order. And then once it is revived, we take up this matter. In the meantime, you file your reply.
Basis of petition.
That is the only way out. Isn't it?
The consent order would otherwise remain. My lord. Only thing is,
Whether it remains or not, we'll look into it.
Right.
As of now, I say that though I have recalled, but I have not touched the contents of paragraph 4, 5, and 6, which is the consent order.
yes, yes.
I further say that the same shall be subject to further decision, taking into account the report which have been submitted by the commissioner. We'll look into that. So therefore, the commissioner's report will now has to be brought in. One. Now, in the meantime, his suit has been dismissed in view of this. So he has filed a review. So you take the copy of this review of my order and show it, and they will restore it. Once it is being restored, then the things will move. And in the meantime, under what provision a suit can be dismissed?
Not, I was not holding the
They
brief
had
for
one-
defendant, but I
What is
believe
the-
they were
have a
invoking
bill.
151 because of that other judgment where it says infructuous suits can be closed.
Is it?
There was one, if I remember. I don't know what they relied on specifically.
And the other is an application under order 6. The prayer made by the
That is
plaintiff
not
is allowed and
comment.
subject to the cost of rupee. So here amendment is allowed. Once amendment is allowed, then the suit was filed in the year when?
16.
2015.
No.
Okay, once the amendment is allowed, unless you challenge the amendment, the amendment has been challenged here.
No, they have not.
Unless you challenge the amendment, then obviously 151 application is gone for a 6. Let us see who has done this. Why the order passed by the satisfied and should not be dismissed and relief for becoming. So you're only on dismissal.
Be on the dismissal.
This petition is banned.
Application seeking dismissal.
This order could not have been passed. In fact, I would say that this court had committed an error in jurisdiction, a matter which is there ABCD. The court went into FGH. Hello. Mrs. M. Hazarika, who appears on behalf of the respondent number 2 in the suit.
The suit we are.
Respond number 2.
Suit we are the plaintiff. We are the plaintiff.
2 and 3.
We are the plaintiff in the suit.
Somebody else is appearing. You are appearing for respond number 4 in the other application. Means you are appearing for somebody.
Then this we are the plaintiff.
We are the respondent, sole respondent.
In this matter. Okay. Appearing on behalf of the respondent submits that they would like to file a short affidavit. I can't give you a affidavit in reply.
No.
Taking into account certain subsequent events.
That I'd like to say.
Which may have a material bearing on the adjudication of the present proceedings. List this matter again on 9th of June 2026. In the meantime, the affidavit be filed on or before 5th of June 2026. You just draw this order. I think the court will revive it. So, Mr. Chaudhary, I have given everything in your matter. Now what remains in your writ petition?
The prayer and the repetition is only to one of hold the elections.
Understood. But the fact remains here, you can very well make the submission in the other matter. You see, your writ petition is otherwise not maintainable. To hold the election or not, you are just making somebody a party out there who have no business out there. The elections are to be held as per you are a society, as per the rules and regulations of the society. So it has to be done there. Unless you say that your anything has been cancelled or anything to that effect, nothing means in your petition. You have to fight it out there.
My submission would be, there was a direction from this court to appointing a commissioner to hold the election. That is the CIP.
Huh?
That's in the CIP.
That is the CIP. So I have already taken care of that. Because of your writ petition, one fruitful thing has happened, that the matter has now been brought to life. But otherwise, your writ petition is completely meritless. Unless you always think that, okay, let me always stand on the left side of the bar. Otherwise, I don't think there is any other good reason. Because now you can very well mold your thing, whether elections should be held or not, and all these things. You can very well, you are the respondent number 5 in that earlier proceedings. So you have your case. Because going ahead with this case makes no sense.
Eventually, Malad, your worship may like to take up my matter for issuing appropriate direction.
No. When the
Maybe,
request is not
How
mentioned.
can I issue direction? Because if you see the Societies Registration Act, it makes it clear that the register has no business in the internal affairs of the society. They have no business. They may at best say, okay, your registration and this.
In fact, my lord, the statute also does not give power to the registrar to, my lord, go into the, my lord, election matter also. Although, my lord, in some other states, that provision is there.
Here there is not there, unless there is amendment. So therefore, what you do is, your registration is there.
No, my lord, it has been suspended. It has been suspended, man.
You have challenged the suspension.
My lord, in fact,
Have you challenged the suspension?
no, my lord, I said that we find a representation.
Not really. Not really.
Have you challenged the suspension?
In this petition, my lord, to remove the suspension, that prayer is there.
In this petition, it is there. Okay. So suspension is there,
Is an issue.
is an issue. So obviously then it will like,
So your worship will consider, my lord, this CLP as well as this petition together.
okay. Let us see, because otherwise I would not happy. You are setting aside the so far.
Prayers to your worship.
The respondent to conduct 1 cannot be given, E cannot be given. Consider representation 2 cannot be given. Supervise 3 cannot be
It's
given.
not the suspension.
4 cannot given. Read in the nature here directing the respondent to revoke the suspension of the registration. Only E limits. Only. In fact, this prayer, if it remains, it would be in aid for both of you. Are you not members also?
We are members also.
You need your registration.
We need the registration, but we need the registration from 2015. This one. From 2015, there's no registration.
It's okay, but there was a registration.
Once upon a time.
Here, you can also file another writ petition that it should be so and so. But here he has a prayer for removing the suspension.
And that prayer, my lord, they may support.
Okay. List this matter along with so and so online.
Okay.
But it's to originally get.
Hello, check. Outline benches.
No, language.
Sir. Yes, ma'am. Are we audible?
Yes, sir, you are audible.
Okay, ma'am. Thank you.
Thank you.
Hello, sir.
Yes, now you are audible.
Also mistake.
Okay, we can hear you, sir.
Okay.
सब स्टेट इंप्लीट किया है ना वो अलग अलग सबका पे अलग अलग
Actually, last nothing about that. What do you? Registry the one of the number.
Citation with when it's an eight.
দেখি শুনি পাইছ DB, yes. DB method.
So this matter now pursuant to my order passed on 8/4/2026. The Chief Justice have entrusted this matter to be monitored by us. So we are paying for the other states.
Probably there in DC man. That Nagaland is there, I think more Arunachal is there.
Arunachal, Mr. Chandran is appearing.
For Arunachal lordship, I am appearing corresponding 1 to 5 lordship in petition number 16625 lordship.
That I understand. The fallout of this will be, main petition is this 2716. 2716. So here.
716 kilo.
Where is Nagaland?
Nagaland, I think Mr. Zamir is there.
No.
Tali.
Their matter is on infrastructure.
Oh, I see.
On infrastructure, another member. Who is paying for Nagaland? Now, what is the present position as regards the committee's report?
So for it, my lord, so for its preparation of the my lord, draft rule is concerned, probably 80% has been completed. It yet to be completed.
The rules file are not yet complete.
Not yet complete. I have seen the one official on that probably, and there is a note by the. The next, I'll take instruction on what how much it in progress now.
Mr. Sinha, you are there? Yes. You are preparing the draft rules? Are you preparing the draft pay rules?
Payrolls is undertaken by our administrative officer and establishment administrative officer.
He's not on service, it is the pay rules. Who is doing the pay rules? Establishment, no? Accounts. Accounts will.
Wait.
Mr. Sinha, you are not aware of that, no?
Details not ever, my lord.
The last time somebody placed before me.
Yes, administrative officer. May I ask him to appear also?
Yes, you ask him to appear after some time. You take up this matter after some time, ask him to appear. We take up this matter after some time. Let us first take up that other matter pertaining to the infrastructure matter.
Who is my lord the NPMLA cases now?
No, not the MPMLA. MPMLA will take it next one. Let us first take up the infrastructure issues. No, not the item number 1, item number 3.
Item number 3.
Mr. Imsong, what is actually happening? How many posts have been now created?
Lordship, dues force, it has been sent to the cabinet for approval. So we are waiting for that approval, for which I'm not in a position to file the affidavit in terms of the personalities and the form.
What do you think? What is happening as regards the construction work in the new High Court building? Mr. Jamil? What is happening as regards the construction in the new High Court building?
It's going on, but not to the expected level, Lordship.
Anything as regards the furnitures and all?
Recently, I have been informed that the order has not been placed yet. Otherwise, it may not take long time, but approximately 2 months. Now we are towards the end of May. So I have little doubt whether they will be able to supply within the stipulated time. Honorable Chief Justice has targeted end of July as assured by the law department people. But then I'm very skeptical with regard to the timing, Lordship.
So there is no further new.
Otherwise, once that is supplied, I believe everything can be possible.
No, understood. That is required. But another thing is, apart from that, there is a little bit of interiors to be done in the courtrooms and as well as in the judges' chambers, as well as in also in the bar and all the other chambers. Something has to be done.
Yes.
Interiors are to be carried out.
Those issues can be expedited, Lordship.
issue of
Because the post-creation, it has not happened.
लेकिन हाई कोर्ट का रूल्स होना चाहिए ना कवर कर तो वो सबने आकर यहाँ कर भी
Mr.
The committee
as regards the post-creation, anything has happened?
हाई कोर्ट what is it would stick to that
Gauhati का सुनाई नहीं दे रहा।
Because in terms of the order dated 7/4/2026,
Yes.
there is a submission which was made that on the next day, instructions would be placed, which were sought for by the order dated 10/3/2026.
Yes.
Have you received anything, Mr. Im Song?
No, sir. No, then right after that, I made an inquiry from the department. Now regarding the MTS for posts, it was submitted by the for approval.
Now, we asked for one thing out there, taking into account that those officers which are those MTS, whoever there, you want to bring it from other departments very well, but it
Yes,
has to be
yes.
under the control
So,
of the High Court.
yes. Whether those MTS will be under the administrative control of the High Court or not.
They have to be, otherwise it will be very
Yes. Otherwise, it will be very difficult to control those stuff.
So you have not received any instructions on that?
No, I am yet to receive the instruction, Your Worship.
Okay. You put it on affidavit, whatever instructions you have received, we fix it another date on that aspect.
Worship. Lordship, another aspect which we are having a peculiar problem with regard to the shortage of staff, especially the filing section. We get it listed within 3-4 days, and in Kohima, the number of cases are less. So if I file today, at least by day after tomorrow, it should be listed. Even if tomorrow, okay, considerable, but day after tomorrow, it should be listed. But in 3-4 days, it takes time. That is because of the shortage of manpower in the filing section, judicial assistance. So if something is done, and that aspect, it will be a great help for us. We don't want to blame the registry also because they are also facing the manpower shortage problem. And in between, we are at the receiving end, Lordships.
Okay, Mr. Jameen, next week I'm there. Take it on first-hand information.
Hopefully, Lordship can bring some solution to that problem.
Okay, then we excuse you. Yeah. We'll pass an order fixing another date. In the meantime, you get your instruction, Mr. Imsong. Now, what has happened out here as regards the shifting of the CGM? Have they emptied it?
Yes. Six have been fully constructed. 7 courtroom, that is, it will be over by 1 or 2 days. There's 6, they say within 45 days it will be over. 45 days. I got the report in the total 13. Yes, Mr. Gogoi, how many completed? 6. Total 30. Total proposed 13. Yes, 6 completed. 6 completed and 1 7-room wide. They say, only the judges part chamber is to be completed. So by 1 or 2 days, that will be over. And remaining 6 days within 45 days will be in the outer line they say. This is in exclusion to what is existing as on date already composed. Yeah. Now, are we having then 19 courtrooms? No, total is 13. Total is 13. After vacating the second floor. How the second floor, how many courts? Second floor, they say 10. 10. Yes. Out of 10? Out of 10, my lord, 3. 3 completed. 3 completed. Fourth one, they are saying, well, it will be over by 1 or 2 days. Only the target is so 5. Net remains is 5. Remains is 5. In the second floor. Yes, in the second. So that will complete the entire floor. Yes, entire floor. By 45 days, they say. And what about that sitting area arrangement for bar and all? That part, do we see the chart under the reply to all it? And what is the seating arrangement for the lawyers? That part is probably my lord, in the second page, also will see in the chart. There are dedicated waiting and sitting area in first floor and second floor, provision as part of the. Which column you are referring to? The second. Dedicated waiting and sitting area at the first floor and the second floor provision as per the approved drawing. Well, these are the, my lord, updates, my lord, as per the drawing, my lord, whatever was there in the drawing. Regarding the ground floor part, on that day when doctors go visited, that part will have to be looked into because it is not part of that. And not part of it. It will have to be a new design and drawing. That will have including that whole building of some mode of the record room. No, because Mr. Once we shift also, your problem as regards vacating that area does not get solved unless you take care of this. See, the main problem is we are protecting the lawyers out there who are residing in this particular place, who are having the sitting area in that building. Once they shift, you are obviously going to demolish everything for this bar. So therefore, your problem is not solved unless dedicated area is made on the ground floor. Here we are having the courtrooms, it's okay. But then also that problem is remains after 45 days. That next question will come. So
instead of waiting for next 45 days.
So within this 45 days, my lord, let it be sorted out, my lord.
At least some designs how to propose without spending too much, like you have proposed some floors.
Yes. That would be one of the things. And regarding the lift part, my lord, there's a lift. That probably, my lord, proposal will have to go from the department.
To do what? Lift is already there.
No, lift, in fact, yesterday, it's the day before yesterday from our High Court, on the administrative building side, it has already been passed.
Yes, then, my lord.
So then you have to.
Yes, madam.
Move it, or you must have, you were present out there.
Yes,
in that
yes,
meeting.
yes, I was.
So as regards the lift, we have already passed.
No, no, as soon as it comes to our department, we'll issue the approval and then the, that will be taken forward.
Because after 45 days, if you, even if you have the building, you will have to complete the lift within
Yes, yes,
45
we'll do it immediately as soon as we get it from the High Court.
And in the meantime, you also consider making at this point of time, within 45 days, a ramp to go to the first floor. Because there, otherwise the problem would be as regards the disability. This is a very important aspect. Huh?
It is
As
little
regards
stiff,
the
my lord. The
disability.
PWD said it is probably feasibility issue has to be assessed.
Ah.
It will be very stiff.
Very
The
stiff.
staircase, the front staircase, it is very stiff.
Very stiff.
Because you see,
Ramp may be not. I have also some doubt.
as regards lift is okay, but the lift may not cater for so many people. So therefore, you make it, when you are already constructing on the ground floor for the purpose of the lawyers, at that time also you have to come up with a proposal for the disability, how to, disabled person, how will they
will explore. Let us not straight away say that not possible. But correct possible. Some not the RAM which will go from straight below to top. Some alternative thing can be. Some alternative for those people, at least to go to first floor. Correct.
Yes.
For us to conceive is very difficult. We are lawyers. But for Mr. Gogoi and his department, there is no, they can do anything.
Mr. Gogoi is expert.
Okay. So we are done with these two. So
Yes, these two part.
Then paperless.
So far, paperless court is concerned, my lord, 3.85 crore has been sanctioned by the government, my lord. The money has already landed in the High Court.
It has reached the high. Yesterday,
Money is here, where the PNP? No PNP. You got the money?
Yes.
Then,
Exactly.
Now, how many more?
and how much is the digitalization in 2 weeks? As regards in what portion you have already digitalized, because this will be required. Yes, Mr. Dwara.
Lordship, till today, we 267 files comprising of 54,771 pages have been digitized. Till today, we have known.
What is the number of remaining files? Tell us that.
Pending files, it has not started.
These are all disposed of.
Disposed of. Only
No,
one.
no, no. You see, we cannot go ahead with the paperless unless you have that. Why are you not asking? Because when this particular contract, the present contract has been granted, it includes the pending as well as disposed of.
Yes, Lordship, yes.
Now, if you are going ahead with paperless, then you have to go ahead with you have to go more priority in respect to the pending.
Yes, Lordship, for pending, there are some infrastructural challenges is going on. Maybe by the end of this month, it will be done.
What is the
means,
infrastructural issues?
there are some pending issues of procurement of tables and chairs. For people.
But you said 3.5 crore you've been given to digital and you are saying about tables and chairs.
That our account section is doing. Account section is doing. Today was the
That
last
day,
day.
that day we had a word with the Register General as well as you. You were not present. But we had the word with the Register General, then we told him that kindly provide the necessary area in infrastructure for the purpose of initiating the giving priority rights to the pending. Should be provided.
Hall rooms are provided. Hall rooms
Because
are
if you don't do it, it makes no sense.
Yes, tell us when can you do this? Why you need a man to give arrest tables here?
room is there, but
Yes, accounts.
accounts are.
If you don't do it, then how do we as a monitoring branch can implore upon the government to give you funds?
But Lordship, the
They have
deviation-
given you a particular fund for the purpose of paperless. Now at this stage, we come to learn that you can't go ahead with the paperless.
No, no,
Because
okay,
of
we
the
can
fact
go
that-
ahead, Lordship. We can go ahead with the paperless.
Huh?
We can go ahead with this paperless thing. They have been set up their workflow, how to do the entire digitization kind of thing. Now, once these table chairs are placed and files come
So
in,
only obstruction is tables and
table
chairs.
chairs.
And you need 1 month to obtain those tables and chairs.
Yes, actually 7th, today is the last day as said by for tender. Today is the last day.
For tender.
Yes, they put some tender for procurement of tables and chairs.
Tender for what?
Procurement of tables and chairs.
The huge quantity.
Yes, and there is one more.
What is the cost?
Quantity,
Cost.
I think it's 25 tables and 25 chairs.
And what is the cost?
Cost means today only they have, I think today is the last day for opening the tender.
No, no estimated value. In the tender.
And now, let's say the figure is not available with me, but thing is that we are advised to close the tenders. Otherwise, we may procure the things from the them also. But available.
That is what
We are able to
25 table. We
close
are
the
delaying a
tender
major
before the
project.
time is full.
This is a priority. More priority with it, because we are also taking up the matter on priority basis for this project to complete.
Okay.
Deadline of supply under the tender.
Let's say right now status I have to confirm it, but if even if in this case, if we are asked to cancel the tender and go to them, I think it will save the time. Because we create a link with the Godrej and they will supply the tender.
But that decision has been taken in administrative side to go for tender, maybe by some committee.
Maybe, but there will be later stage.
No, this tables and chairs, it is under ICT or some other company. No, it is general supply, that is.
Okay, let us go to the next one. The funds have been given.
My lord, so far as JM is concerned, my lord, there's some development, my lord. Conditional exemption has been given by the government to the High Court and the District Judiciary, my lord. We have issued the letter to the High Court.
So this is what we said earlier. So this is so the exception is given, which will come within the ambit of if it comes under 1, 2, 3, 4.
Yes, my lord.
So if these are the formalities which are to be fulfilled, then you need not go to jail.
Need not go to jail. Yes.
So this is what we discussed.
Yes, my lord. Following your lordship's observations only, we moved finance department and then this has come out, my lord.
One thing. So far as capping with regard to district judiciary is concerned, my instruction is that capping is still there for the district judiciary.
No, they have to apply their mind, the district judiciary. They have to know how to apply it. We have made certain interactions in the court, and the finance department or the judicial department have taken the cue from that and have come up. This is the conditional. And if you see out here, if it is necessary for urgent requirement directly connected with judicial functioning, wouldn't that come within the ambit of no,
So
without
far as
them?
reappropriation is concerned, reappropriation, that has not been done with regard to the High Court is, well, my lord, High Court is fine. There was a proposal for reappropriation.
This is not relatable to capping.
This is for GEM.
GEM. GEM is something different.
It's a different
GEM
thing.
is to exclude the tender.
Correct.
GEM.
So far as GEM is, there is no issue.
No issue with GEM.
Yes.
You have said so.
No. It's since it was discussed along with GEM last occasion, so that's why. Fine.
There are two limitations so far, cap relating to High Court and district.
Yes.
There is no cap for the High Court as of now. And
Yes.
whatever district.
District judiciary also cap is not there. And this will ease out, my lord. This notification will ease out the entire difficulty.
This is for GEM.
No, this will ease out. Capping issue.
Now, you, under, as regards the High Court, that was the head of the account was 1.5 crores. Now, what is there for the district judiciary under what head?
Yes, sir. A letter was sent for exemption or enhancement. It is pending.
Now, what is the amount
3.5 crores.
for?
District judicial.
3.5 crores is there. So it is the capping is there. So obviously you can apply this.
So, looks like for enhancing the capping, a letter was sent to the judicial department.
What is the present capping?
Present capping is 2 lakhs. 2 lakhs.
2 lakhs you can't have that, na? Again, the same principle will apply.
Yes, my lord. Yes. I think with this notification, my lord.
So this takes care of, you see, what has happened. Earlier, what was happening, they were having a 2 lakhs, giving it to the judicial department, whereby the judicial department, the secretary, the judicial department is considered to be the head of the department, and a registered High Court, General High Court is the liaison officer type. This was being done. Now, what has happened is, which obviously should not have been. Now, for your office, 2 lakhs is fantastic.
Fine. Yes.
But for the High Court, now they have enhanced to 1.5 crore. Now, for the district judiciary also, you need to have it, which is commensurate with their spending on the housekeeping. So therefore, you need to take a call on that. You have only done for the High Court.
We'll see to that, but my lord, it should not be a problem after this. After this.
No.
I have not understood.
Lordship.
This relates to exemption of certain procedure
in certain
Procurements.
procurements.
Yes, no.
And that is so far relating to capping.
Capping.
Even if you go by this procedure, you cannot go beyond 2 lakhs. If
That-
I'm not clear. So
Followed-
we are
followed, Doctor.
talking about that capping.
I understood.
not the Procedure.
Yes. We'll see to that, my lord.
Earlier it was 2 lakhs for everybody. Now for High Court, you have come up
1.5.
1.5 crores subject to 3 conditions. Amongst the 3 conditions, we are done with it, and one of the conditions was you mandatorily required to do it through GEM portal. Now we put the question to you, how do you go for GEM portal for these matters? And we suggested these are the exceptions. And these exceptions have now been put out there in this particular communication. Now, similar exercise has also to be done in respect to the district judiciary, which commensurate with the district judiciary. High Court is a small unit compared to the district judiciary. District judiciary has so many courts. So therefore, you have to have a commensurate thing. And there, if there is a spending out there, there has to be again applying those 3 conditions, which includes this.
We'll see to that, my lord.
Correct. Yes. So there we are done with this housekeeping. Then what remains? Oh, we asked you to place something else, anything else or nothing?
This is with regard to my lord MHA resolution in the meeting held on
Just
my lord
it,
5.
just it, just
I'm
it.
sorry. Yes, creation of NDPS courts, my lord, in 7 districts, my lord. I have given the documents, my lord.
Give it to Mr. Gogoi and
I have already given, my lord. I have already given, my lord. The the resolution start from page number 21, and so far as the Assam is concerned, that page 25. 7 districts were earmarked, my lord, Kamrup, Nagaon.
Just it.
I'm sorry, I'm sorry.
Our state of Assam is?
Page 25, my lord.
Yes, read it.
So, my lord, may I read, my lord? Assam, in respect of Assam, keeping in view that about 11,000 cases are pending and no special NDPS court has been established yet, it was suggested that 7 executive courts may be established in Assam at Kamrup, Nagaon, Dhubri, Tinsukia, Borpeta, Morigaon, and Kabi Anglong. It was informed by the state that approval of 7 courts have come from High Court. However, the staff strength of this court is being discussed. The UHS advised the state to go ahead with the establishment of the courts. He also stated that a central scheme for such court is under consideration and the state will be reimbursed. It's absolutely under the central government scheme, my lord. Now, after this, we have sent a proposal, detailed proposal. Yes, after this, my lord, page 33, it was a communication by the Deputy Secretary Government of Assam Judicial Department to ask to take steps, my lord, with regard to that decision. Page 33. Then page 34 is the proposal that we have submitted to the government. including financial implication, my lord. Page 46 is the financial application. But thereafter, my lord, things are not moving.
I'm not to understand that this was done pursuant to a judgment passed by the Supreme Court.
Yes.
NDPS, yes, my lord.
So why don't you place it before the Supreme Court that the state of Assam is not helping, although the center is ready to reimburse?
It can be done, man.
Put it on affidavit before the Supreme Court. But you better, na?
And one more thing, my lord. I'll give the data of the recent data of NDPS cases, pendency of NDPS cases, my lord.
What the 11,000 cases?
No, that is of 2023. Now, Procedural candidates.
So NDPS cases have increased.
Yes.
It's okay.
Malo, there is some differences with regard to the selection of the district as well, my lord. Those districts which deserve an exclusive court, my lord, was left out because those were selected from. My lord, we.
High Court.
Yes, my lord, because a meeting is to take place, my lord, in the administrative side, my lord.
Okay, which other districts as per you?
Yes. I have to come prepared, my lord, for this. I have not come prepared for this.
Don't come up and make this type of submission.
I hope they are not reducing the districts.
Are you saying that Kamrup Metro doesn't fall?
Kamrup Metro, already there is an exclusive court. It has started functioning from 1st of May.
As per the new scheme.
As per the earlier, it was done earlier, but it was not functional. Now it has been made functional from 1st of May. So
Under this scheme.
Under the scheme, exclusive. Yes, exclusive, my lord.
So therefore
It would come under the scheme.
It takes away out of 7 1.
No, no, it is exclusive. It is separate.
This is not.
It was already there.
Accepted, then there are two courts, Facil and this court in Kamrup. What is the setup of Kamrup Metro?
Kamrup, serial number 19, man.
Huh?
20, serial number 20.
You have 2 courts required.
Yes, ma'am.
You see the other districts. I don't know. Hey, Gumi. Nagaon. Nagaon 1023.
Nagaon, 1283.
1023. Oh, 128.
1283. We'll have to add. Then Tinsukia 662. All are very high in number.
And this includes in the proposal. Then
Two courts are there, my lord, which may not be there.
My understanding is that this 7 will remain. If they want to add some district, my lord, due to the high pendency, they can add that. But since this is a decision of the central government, this has to remain.
Karbi Anglong, my lord, the pendency is not that high comparatively. It's below 500.
Mr. Allard, let me tell you, Karbi Anglong had grade 1 officer post.
Yes.
One is of the post of a district judge, the other is the post of a
Additional
district judge. Additional district judge, that post has not been filled up. You don't have an MSCP code there. Okay. So these 470 plus
499.
499. 499 we are not on that. Let us go on the 470. 470 is now to be dealt with by the district judge.
That's quite high.
Absolutely. Now that is the reason why this is the biggest problem which is being faced, and you are aware the Karbi Anglong is the border district from all the entire things which come from that area. The
This one and others, Sribhumi and Basu.
yes, the major catchment area is in that area.
Well, the MHA actually, my lord, they fixed a threshold of 1,000 cases. I mean, exclusive.
Who fixes?
MHA was.
Can you go beyond the MHA's resolution? MHA says these are the identified courts. We are ready to pay money. What is your objection? You are saying this number,
No.
that
No,
number.
after this, my lord, there was another meeting, my lord.
Uh,
So where we pointed it out, my lord, MHA said that you decide about the districts and then that will be approved. So there is no difficulty with regard to that,
So
subject
MHA,
to.
you mean to say have changed these districts?
Yes, my lord, there is a subsequent resolution
So
after this. And I don't have with me, I don't know whether they have included it here or not, but there is another resolution, my lord, after this.
And you are not aware which are the districts also.
And it's not yet decided. It is to be decided in consultation with the High Court. The NCB has also been instructed to coordinate and give their inputs with regard to selection of the districts.
period of next, till the next,
My lord,
we sit on the.
My lord.
Sit the next.
we can do it, my lord. My lord, NCB was also suggesting, my lord, that 2-3 adjoining districts, if they can be added together, they have also
That
raised
we
that.
think later on.
Yes, my lord.
Be clear on your propositions.
Right.
That these are the identified districts. Then we can think that at this district and that.
Yes, my lord.
First, we need money from you. We need construction from your side.
Yes.
And get it reimbursed from Mr. Destitute.
So on next date, you give us the, and we recorded that there, that it's your contention out there, that pursuant to the MHA's decision, we allocate these 7 districts.
There was another.
These 7 districts. There has been a further move for
including more districts.
identifying other districts.
Other districts.
Than these. Moves. This is for more, not more.
And if more also, they have given us that flexibility, my lord. If deserving districts are there. There is no fixed number, my lord.
No, but 7 is number is fixed.
Big number.
So
we need to.
So therefore, the question
Yes,
is.
my lord. We need to pick up the right
there
district.
cannot be a stalling of this 7. We are, the moment
Yes,
we are
yes.
saying more, so then why these 7 have not been approved till now?
Yes.
You carry on consultation for additional.
But these 7 is identified. So we therefore say that there would be further consultation, but as regards the 7, you immediately take it up.
My lord.
7 is final.
7 is final.
So therefore, 7 is final. There is nothing new about.
Yes.
So 7 is
Therefore,
final.
reconsideration is for the reason that in the meantime, they will re-verify whether any additional courts are required, cases have increased. So that's why the further consultation, that cannot stop you for what has been decided earlier in the year 2023.
Because it may so happen that.
No, it has been decided recently, my lord.
No, this decided.
This list is recent.
But 7 courts.
It is recent, my lord, only.
No, 7 is fixed. As per the MAC resolution 7 is fixed.
And that was the earlier that thereafter this modification.
Now, where is the modification?
Modification.
We therefore to record that there is a chance of modification of these districts.
Yes, my lord. Yes.
Addition. That is
Modification, addition also may be there.
Addition is different and modification is different. Modification means that these 7 districts which have been identified by the MHA would change from Nagaon to, just for example, Nagaon to, it may go to Gulaghat. Is it going to change that? No.
If the case deserves like that, I mean, the
No,
number
so
of
there-
cases.
Is there a chance of modification of this 7?
Modification is there, my lord. Chances
So
there.
where is that?
There is the resolution. Another, I am not having the copy
So
today.
therefore, once that is being given,
Yes.
then you must have floated a proposal that we don't require it in these places. Otherwise, MHA would not know.
We have pointed it out, my lord, that these
So
have
you
lesser
don't-
number of cases.
You don't point out verbally on a written aspect. You must have put a
No,
proposal.
it's on the basis of the pendency, my lord.
No.
When have you
You kindly see, Mr. Kindly see here.
This was the-
Page 34. Kindly see here.
Even if you go by the pendency, these are the 7 courts which have got highest number of cases.
These 7 percent, out of this list, they are the highest. So
Exactly.
here it is saying there, in respect to some keeping in view that about 11,000 cases are pending and no NDPS special courts have been established yet, it is suggested that 7 exclusive courts may be established in Assam at Kamrup, Nagaon, Dhubri, Tinsukia, Borpeta, Maurigaon, Karbi Anglong. But yes, I think there is a problem. You don't have Kachar, those
my lord.
border districts.
Yes, my lord.
That's why you want to
Yes, my lord.
give addition.
Yes, my lord.
Because Kasar is most important.
Most important
Kachar
is
and
that.
Karimganj also has high.
Assam and Karimganj.
Karimganj.
These are already the highest number.
Yes, my lord.
Yeah,
If you
these-
go on number of cases, this will top the first 7. And you need to add Kasar because Kasar is also like that only.
You need Sribhumi.
Sribhumi, in fact, it's more than Kachar.
So therefore, now this question has been arising, so therefore they will add this. Principle remains the same. We'll proceed
may
with the
not-
7.
No, what I suggest, my lord, that
440. 440.
between this.
Would be 763.
And
Seven-
Kamrup rural or Kamrup or Kamrup, you require.
Kamrup rural also has a high pendency, my lord.
So therefore it is Kamrup rural they mentioned.
Rural. Kamrup rural actually.
So Kamrup Metro would not have
Okay.
another one.
No. He's already having one.
So therefore the that's why 2 will come. So Kamrup rural would be 1. So that is okay. Then Nagaon is okay. Dhubri is okay. Tinsukia is okay. Borpeta is okay, no? Morigaon is less.
440.
440.
Morigaon is also double.
Borpeta little less, my lord, comparatively.
440 is not a less number.
Comparative 2 percent.
2.
But there you don't have the more important is if you see as per the seriality, you should have Sribhumi.
Sribhumi, yes.
So you will give an addition to Sribhumi and continue with others. Come back to us.
My
An
lord.
immediate decision.
Yes.
And money is not from Mr. Gogo's pocket. It is from Mr. Dev Chaudhary's pocket.
Yes, my lord.
Then Mr. Gogoi, show the good work without spending money that we have done it.
Okay, so we are done.
Any other?
One small issue, my lord. We have, my lord, 13 judicial officers whom we are unable to impose the. My lordship, I'm just passing status report. So, the status of creation of infrastructure for the courts which are lying vacant due to lack of infrastructure.
Where is that place?
We have prepared a chart, my lord, that will help you, my lord. Help you, lordship. There are 13 posts which we are unable to fill up.
Have you given it to Mr.
Yes.
Gugoi early?
Yes, my lord, we have already given. So here, my lord, in this 13 infrastructures, my lord, we need to give special attention so that the judicial officers can be posted. Majuli and Kachar, I have been instructed that these are works going on, but just to compile it, it has been. Yep.
Das.
Yes.
Ask Mr. Gogol to respond.
Correct, sir. I'm not asking for any decision today itself.
No, and we are not also commenting on.
It's absolutely fine, Milo. Let my brother Milo take a call on this, Milo.
For looking to NDPS, certain
Yes.
things are admitted that it is.
Fine,
By
Fine,
Congress
fine.
history, then already 7 course proposal is accepted
Exactly.
by.
Yes,
That's, if you want to add, you consult.
yes. Fine. So for this, they will take a call, Milo, that will serve the purpose.
So we are done with this.
Yes, these are the basic issues.
So we are having this matter on 11th of June,
Milo.
last order.
And in the meantime, you have consultation for additional.
Well, we'll have.
Now this Gauhati High Court, yes. So here it will be another 80% has been done.
Done.
Person has not come. Yes. Yes, yes. Yes, what is your status as regards the rules?
Lordship, it is 80% complete.
Oh, that was,
We need some information from the outlying benches.
okay.
Because it is a uniform pay rule for the outlying benches also. We need another 2 weeks time to complete it.
Okay. So let us get an update on 11th. Possible to give an update?
Yes.
Only thing, Lordship, we have submitted the report as well as the structure on uniform pay to the government as back as in.
We'll look into it. First, have you made the rules?
Yes.
We'll take it up, na? First, you make the rules.
Actually,
Because you have to make the rules, then place it before that committee.
Yes.
Now, has the
Yeah.
Mr. Panging,
Yes, my lord.
yeah, you see, your case is now under consideration in these rules.
Yes, my lord.
So let the rules be made, and then
My
we
lord.
will share a draft copy upon to you. Then let's see then whether your action, your thing has been duly considered in the rules or not. Let us look into it.
My lord. Lordships.
I think then.
Yes.
So we have it after it on
Yes.
11th again. That will be dependent upon the rules being made. Once the rules are made, then only things can move.
Yes, yes, absolutely, my lord.
Okay. Okay then. Yes. We are having
Alright.
it again on 11th.
11.
Okay, Mr. Panging, we are having that matter again on 11th. Nice, rookies.
Lordships are
How
audible.
do
We are here. Yes, we have heard.
yes. How do you expect the matters on? We are having an issue, an SOP that on Mondays and Fridays we are going to have all matters through video conferencing, although with a special emphasis with the word preferably. I think how would the SOP work if we are having this type of connection?
For us, one of it is
Absolutely, your lordship.
because our files are here. Ultimately, we need to come. We'll try. Well, on last occasion on 7/4/26, Lordship has directed us to paragraph 7, my lord. The registry has given us 2 lists and Lordship has directed us to assign each case. That has been done, my lord. I have given the list. You have given. Look, all cases have been assigned. The public prosecutor APP has been assigned. As per the list.
So everybody has been assigned.
Yes.
But then I don't think we can see substantial progress. Yeah, yesterday some order came up in that Ashwini Kumar Upadhyay. The order. इसने कल ये तो देखा बच्चों ने और expenditure Ashwini Kumar. Prepared, I think that registry prepared.
Is he prepared a list, my lord, and last part, my lord, where the MLAs are, my lord, complainant, that can be, my lord, that we get.
No, we have asked them to.
Yes, that is there, my lord, that is the
Two lists they have prepared and
two
given.
lists, my lord, one is old and one is very old. And one is, my lord, very few.
The records.
That is that is sign on, my lord, 3/34 to 2026, my lord.
This one.
Yes.
This appears to. Now, how many matters are there?
So, my lord, first list, my lord, that is up to 2016. Up to 2016, my lord. While Assam is concerned, my lord.
There is around 24 matters. 25 matters.
23, my lord.
23 in the High
In
Court,
Arunachal,
in the state of Assam.
2 in my lord state of Arunachal. And the Mughal one is 2003 matter, my lord.
How many of you have signed the reports with the monitor the cases and those not to take any adjournment and please someone please start in time and they get for the
So we give this emphasis on these first 23 matters, didn't it?
Up to
Those are
16 matters. These are all.
Yes, those are all
These are all.
prior to 16.
Yes.
These are individual.
These my lord, yes, these are the MLA MPs are only complainant. So these are not included in my lord this because those who are accused.
Yes. There is C, black C, is that a black C? Yes, Mr. C, black C. No.
Because G will little where MP MLA are complainants. Now we have nothing to do with this.
Nothing to last, there are my lord 7 matters. Item 4, one number, very last my lord. 1 to 7.
One is something different, state of Assam,
And Rajdeep Roy versus Puzzle.
We are not concerned with this matter. So therefore, we only pass an order now that and in respect to these matters, more particularly these 23 matters, Mr. Phukon, you have already provided, you have assigned PPs. Okay. So this, no, these are new matters. This document which you have given, Mr. Nath, this is all, see, only one matter I could find, that is, I think, that is the document of 29/4/2026, wherein 2 special vigilance case, 5 and 6 have been given to one Mr. Jogeshwar Gogoi. Remaining are all new matters. What about the old 23 matters?
Well, all cases are given. If Lordship kindly comes to. Yes, one of the special vigilance case number 5 of 2012. All cases we have given. Well, in respect of public prosecutor Dibrugarh, kindly come to Malad. 2003 case has been assigned to Michu Bodole.
Give a list,
But in fact, court-wise we have given. Court-wise we have given. District District wise, the public prosecutor Dibrugarh has been assigned all the cases related to Dibrugarh. Now.
Total 23, no?
Yes, total 23. That while assigning one from both the lists we have given. Lordship, may kindly go by the districts, Malad. Public prosecutor Sribhumi is the first. But kindly go by the districts. Districts. Yes, yes. Lot.
Come to first page. It is 2018. Yours 2016, is that it?
First is related to Sribhumi, there is one case. 18.
Forget about the.
Malad.
Just come.
Yes.
See, you said, on 23 cases up to 2016. Now let us see from these.
One.
Oh. First cases and from in this case 3, 2012. So this is 2.
2.
Okay.
3 total 3.
Then come to case, it come to district
Dibrugarh.
Okay.
Lot.
3.
Logic.
Then come to district Kamrup.
In Dhubri, Lordship will find next page. 19 is there.
No, not like we're 16. So 3.
Oh, sorry.
We are 3.
3.
Now come to Kamrup. 3, 4, 5, 6, 7, 8, 9, 10, 11. Now count this to 11. Then next this is here 14. So we get a total list of 14 only.
Till
Then if we go to the last case, 15, we have 16. So total assigned cases up to 2016 is 16.
Kindly, I'll take your lordship once again. But the lordship. 2018 first is
not
1.
2018. We are up to
16. Sorry. 16. 16.
No.
In Kamrup, lordship will find many cases. Many cases.
Already counted. In my count, it counts to 16. 7 is in million. Each side was 7.
But we'll be from side. We'll be from side.
As per your list, it's 16.
We'll be contact. Okay.
Mr. Pukon, you do one thing. Have you been provided the list, the present list which have been prepared? Yes. So
Now,
accordingly on.
you do one thing. One, taking into account the judgment in Ashwini Kumar Upadhyay. So, taking and in view of the lot of matters being there, we have segregated up till 2016. As regards the 2016, you already appoint. post 2016 also you need to appoint.
No, they have appointed, 25 also they have.
Understood.
So we need the whole list
So-
to be appointed.
So against this, just check it out as to whether they have been appointed or not.
Or any
And if
cases
not,
there.
not appointed, look into it and appoint. So this is what you need to do as regards that. I think that will serve. And then we'll take an update after 2 months. I think better option.
More for my. It was. Tell us. It's state that might be the present status of case is from proceedable. The case was received and transferred on 19/9/2024. It was earlier or in some other court. Anyway, we are not going into this now. But now 118 witnesses have been examined. 100 we have seen. 118 has been quite and the including retired PSP, retired assistant commandant, retired inspector of police. The next date of hearing fixed on 10/3/2006. The court has directed counsel also to file a report. Good. Well, not now it is more or less in the line, but it.
Now it is in the line, yes, please.
What is the status in High Court?
High Court might not consider you progress, but the hearing in High Court was not included.
No, I asked for.
I still think it is that. Because most of the revision was seen, but appeal, like nothing to the appeal panel. So far is kind of revision, but some stay order was there, probably.
Because this connects the original case. Right?
Yes.
If stay is continuing.
Continuing, that will be
every 2015.
But
That also will be.
just 1 month, like the progress 2 months.
No, in these matters, you do one thing, within 15 days, you allocate wherever it is not there, taking into account the list. We have this matter for an update after 2 months. Not now. Not. We have it sometime in the month of August. To be notified later on. We won't put the date now. We have it notified later on. It will be obviously a Thursday. Either it will be 6, 13 or 20 or 27, whichever you. But in the meantime, within 15 days, you will
Give us a good progress. One more.
Oh, Mr. Foucault, there is no of the record nowadays. You are on live.
Yes, sir. Asked one of the last station, one case was discussed regarding the NDPS case, the special court. But I have one of the special court was set up, but there is no special people. That may be direction to be allowed to appoint special people in review. Because the court was there, but the special people.
Which one?
Our regular cater people not. Kamrup.
The Kamru,
The NDPS special. Because our regular cater people cannot appear in a special court. That's why special people is needed. But I have might have informed you. So that proposal is to come from whom? Like the court. Yes, the court will finally directed the LR to appoint special people at the same. No, then LR will give the proposal to.
we do one thing. You inform Mr. Nath. On 11th, we are having the other matter. We then insist on that and pass. it. You will take care of it, just inform him. Not on the next day, we take it up. No, we'll pass a judicial order when they are doing it. And then we'll say, the High Court also inform us that there is no PP there. Because in this matter, we cannot, because this is only MPMLS. That is an NDPS matter where special PP to be appointed or not is another, can be very well taken into consideration there. So we will pass an order on next.
You can also notice of LR. Can bring that as regard informally that out of the record.
Not.
Information in the process start. Because see, judicial officer is there, then
There is a question that the CLPP has not done quasi no jurisdiction, what, but maybe.
I'll take up.